whereby, my lord, the challenge of the proceeding at
Motion.
my lord.
Motion.
More, my lord.
This motion is okay, no problem.
Oblige.
May Lordship. Lordship, I'm praying for listing one WBC Lordship. File on 18.
Motion or what?
Yes, motion. Lord.
Motion, no need of mentioning. We'll have it whenever you want.
By tomorrow.
Whenever. Today also, if it's possible. This is the motion week. Tomorrow, yes.
I'm paying for listing on day after tomorrow.
Motion.
Day after tomorrow.
For motions, all mentions allowed.
Lordship, kindly mention listing Lordship admission method.
Admission, not. No admission, only motion.
May it please your Lordship. Lordship, I beg to mention item number 26, Lordship.
26, yes.
Okay, madam. 18 of
26. Yes.
18 of
CD.
I'm on interim, my lord.
Hmm?
I'm on interim, my
Okay. AB. What is the offense?
wildlife, Lord.
Wildlife. You'll be appearing.
Lordship.
Will you appear?
No, I'm not for wildlife, Lordship. I'm a public prosecutor.
That is it. That is exactly what we're asking. Will somebody appear for wildlife? Forest Department.
Lordship.
Get the inquiry done. Okay.
After vacation,
This court has been informed that the case diary has not been received. Full stop. Para. List for consideration. When? On
after
10th of January.
Lord.
Interim order passed earlier.
Oblige, man.
To continue. Yes.
May I please your Lordship? I beg to pray for listing an urgent matter for motion
Motion, yes, no problem. We have said already. Motion matters all allowed. When? Tomorrow.
tomorrow.
May it please your Lordship. I like to mention item number 50.
15.
55.
50.
The
Yes.
matter be not taken up as Mr. Ndeka is appearing for respondent.
Okay.
My Lord.
50. Supply list. Supply list from there, I don't know. Oh, yes.
My Lord. My Lord, I am for the petitioner, my Lord. My Lord, some urgency is there, my Lord.
You have to
Yes.
approve the registry. You are not passing any orders. Please before any other bench without me. 50 along with I.
Oblige.
May I please, Lordship?
Okay.
Lordship, I beg to mention item number 2.
2.
Lordship, I pay for adjournment, my Lordship.
Bail matter. Why are you adjourning?
So, Lordship, actually, my senior is stuck in somewhere, so it will.
Doesn't matter. At best, we are not rejecting your anticipatory bail. Are you praying for interim order? Adjourning for when?
After Lordship vacation.
After vacation.
Just
can-
it is required.
Huh?
It
We
is
can call for the case diary. One step will go ahead. Let it reach. If there is difficulty, we'll adjourn it. Okay?
Yes, Lordship.
Yes.
Lordship,
Yes. Anything?
one more prayer, Lordship. I want to. Lordship, what happens in this TN Vigilance Police Station case, Lordship? Special public prosecutor appointed, Lordship.
Which case is this?
It's TN Vigilance Police.
This one?
This.
Item number 2.
Lordship, I'm just to make a
Oh.
prayer, Lordship. So registry may be directed to show the name of special PP CM Vigilance instead of PP Assam, Lordship. Because we
Okay.
are facing very much difficulty. We are not.
Item
able
to let it
technical-
reach, we'll pass that order. We are not passing any order. Okay, let the, since he's praying for time, we'll have it.
Can you pass over for time being, Lordship?
No, we have it after the vacation as per your
After
prayer.
vacation.
A prayer for adjournment has been made on behalf of the petitioner. Full stop. This court has further been apprised that this matter pertains to CM vigilance case. Full stop. Para. List on 8th of January. Not 8th of January. We'll have it in 5th of January.
Lordship, my senior will be not available here.
8th
Yes.
8th of January by reflecting the name of special PP CM vigilance.
In all the cases. Because
And-
we have filed a application also before registry. also,
No,
but
no,
nothing
we
is
can
done.
pass orders only in 2. Other matters are not before us.
Okay,
By saying the name of special PP CM vigilance.
CMB.
Special PP vigilance. Okay.
Oblige.
Oblige.
I said what they do. Yes,
May I please your lordship? Lordship, this contempt case has been filed in respect of the judgment dated 11/5/2023. Passed in the repetition number 3071 of 2022. Lordship, this Honorable High Court White Order dated 11/5.
page. Which page?
Lordship, page 12.
Page 12. Where is the operative part? What is the direction of this court?
To release the bill amount of
Where is the operative part? The brief is before you. Why are you looking here and there? The brief is before you, isn't it? You have said that the judgment starts from page 12. The operative part will be where? Obviously, towards the last part.
page 40.
Yes, please read that paragraph. Paragraph 3. Come to page 13, paragraph 3.
As stated earlier, no one appears for the state respondents even though court hours has not come to an end. This court has also noticed that though this case was first listed on 13/5/2022, no instructions have been placed by the state respondents even after a year. As such, this court is of the view that the writ petition should be disposed of by directing all the respondents to verify the contractual bills of the petition and thereafter pay the petitioner the admitted amount. Accordingly, the respondents are directed to examine the claim of the petitioner and pay the admitted amount. The entire process should be completed by the respondents within a period of 2 months from the date of receipt of a certified copy of this order.
Okay. What happened thereafter? Did you communicate this order to the respondents?
Yes, Lordship,
Where?
they have received
Where? Page?
page number 2. Page,
What happened thereafter?
page 13.
Well, so you be confident and submit for the pages 18, 17, 16 are your representations. We find that there has been some movement also towards compliance.
15, 16, 17, and 18.
Yes, there. What are these orders at page 19 and 20? 19 says your due is justified, and 20 is a letter by the executive engineer or chief engineer. They are doing something in compliance with the order. Where is the contempt?
Comprehensive report towards clearance of pending liabilities amounting to
Madam, what is the contempt? Tell us what is the contempt.
almost 7 months has elapsed.
What is the contempt? Contempt means what? Disobeying, not disobeying, willful and deliberate. We find that there are communications towards compliance. Can you still say it's a deliberate and willful disobedience? Okay, what is your name?
B. Kaklar.
Hmm?
B. Kak.
B. Kaklari.
P.
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 P. P for victory,
Yes, sir.
not victory.
Yes, sir.
Okay. You are victorious today. We'll issue notice.
Yes, sir.
So, Narzari, you are also there in this matter. Assisting. Okay. Very good. Good to see you after a long time. Heard Miss V. Kaklar, Learned Counsel for the petitioner. Complaint of order dated Silova. Order dated 11/5/2023, passed in WPC 307 of 2022. That's what Learned Counsel has also referred to the communications by which the order was transmitted to the respondents, full stop. It is also submitted that though certain further communications, certain inter-office communications, certain inter-office communications were made, comma, the payment has not been released, full stop. That's the issue notice. 4 weeks, okay. Steps by registered post with AD. You take steps by registered post with AD within 2 days. Okay.
Like,
AB Nikiru. Yes.
May it please, my lord. My lord, this connected FIR has been lodged by the administrative officer of Composite Hospital CRPF, my lord, against 2 companies, my lord, who are medical equipment suppliers, my lord. I am not at all named in this FIR, my lord. My lord, the FIR starts at page 12 and relevant portion starts from page 14, my lord.
Page?
Page 14, my lord.
Okay.
Lordship may kindly have a look, my lord. Subject, my lord. Thereafter, an advanced dental chair makes so-and-so model so-and-so was procured from MS Molmec Enterprises so-and-so, Delhi, and so-and-so dated, and the same was installed at CH Composite Hospital, Guwahati on 14/8/2021, my lord. It came to the notice of Dr. Hirojit Singh, dentist of so-and-so hospital on 28/11/2022. My lord, after 1 year and 3 months, my lord, that the said above chair was defective and also reported that another model of so-and-so was supplied. My lord, dispute is between the hospital and the companies, and I was only the delivery boy of the said chair, my lord. I was only an employee of the transportation company, my lord, who delivered the said chair, my lord. Thereafter, my lord, police started to harass me since a few months back, my lord, and I appeared before the police station on 16/5/2023, my lord. That lordship will find at page 22, my lord, and they have supplied me a 41 notice to appear again on
So if
30/10, my lord.
where is your appearance page?
My lord, page
Where is the notice?
23, my lord.
23.
Page 23, my lord. I signed in the notice, my lord.
41A notice.
41 notice, my lord.
So 41A is given. Why are you apprehensive?
My lord, on that day I was assaulted, my lord, and harassed also, my lord.
Assaulted. Where have you stated your connection that you are a delivery boy? Let us come to your averments. Paragraph
My lord, paragraph 4, my lord.
4.
Paragraph 4.
Yes, please
In
read.
detail, I have stated, my.
Please read.
The applicant stated that he is nowhere named in inside FIR, nor is connected in any manner in respect of the allegation.
Have you given any document
No, my lord,
to
document,
show connect with Durga Motors?
document, my lord, I have not.
Okay. You are what is your name? A.
Vikas
Chaudhary.
Sarkar, A. Chaudhary, my lord.
A. Chaudhary. Third Sri A. Chaudhary, learned counsel for the petitioner who has filed this application under section 438 of the CRPC, praying for pre-arrest bail in connection with so-and-so, so-and-so. Huh? Para, it is submitted that the FIR dated 11/5,
11/5, my lord.
2023 has been lodged in connection with certain supplies in the composite hospital of CRPF, which supplies full stop. It is further submitted that the present petitioner was only connected with the transportation of the mechanism of the equipments and is not connected with its quality. And in any case, comma, he has appeared before the IO pursuant to a notice under section 41A
Yeah.
of the CRPC. Full stop. Para. Call for the said case diary. fixing 8th of January. Full stop. 37 so learned APP shall do the needful. Full stop. Para. Heard the learned counsel on the interim prayer. Full stop. After considering the facts and circumstances and also the fact that the petitioner has already appeared before the IO pursuant to notice under section 41A of the CRPC, comma, in the interim, comma, it is provided that in the event of arrest, 10,000. You appear, when is the next date we are giving?
Next date was given on
No, we are giving, we have said 8th question, okay? 8 to me, here, 12th. You appear on or before 5th of, okay?
Right.
On or before 5th for further statement. Or not to temporarily, right? Okay.
obliged.
May I please, your lordship?
Yes.
Lordship,
Yes, Mr.
kindly,
Mishra.
yes,
Have you given anything?
lordship, may I kindly come to page 15, lordship.
1-5.
Yes, of my petition, lordship. Here, lordship, they have taken 2 vehicles from us.
No, we have read your vehicle. On the last date, we have said that anything to do with the liability you are required to put on record. Order dated 15/12/2023.
Last order.
Yes.
The thing is that lordship may kindly go through this page,
Page
page 15, lordship.
1-5.
Yes,
Yes, please.
this is from the office of the Assam IWT Regulatory Authority.
Yes.
Subject request to provide vehicle on a higher basis. With reference to the subject cited above, you are requested to provide 2 good condition vehicles, preferably Hyundai Creta or Artiga, along with driver and necessary fuel for the use of Sri so and so Regulatory Authority Ulubari to perform official duty with effect from 23rd March 2022 as per the approved rate and terms and conditions of the tender notice by number so and so. This is the approval of the chairman of IWT. Further, you are also requested to submit the bills in original and duplicate at the office of the undersigned for taking necessary action. So, lordship, I have got the instruction from my client also, because while taking vehicle, lordship, they simply passed an order, lordship. And after that, they requested us to submit the bills, lordship. And there is no other document. And we have already duly filed the bills, lordship. Everything has been received. So, this may be the lordship admission of liability, lordship.
This is not an
That
admission of
I will not
liability.
make it clear to your lordship.
This is not an admission of liability. Admission of liability is a clear admission that we have to pay this much of amount to you. And maybe for some reasons, the amount has not been able to be paid. That's a different. Okay, we'll issue notice at this stage.
Lordship may issue
Instruction.
notice.
You're on a very crucial time before the vacation.
Lordship.
You've chosen a right time. Heard Sri T.K. Mishra, learned counsel for the petitioner, who by means of this petition has prayed for a direction for release of bills pertaining to hiring of the vehicles of the petitioner. First the para, issue notice returnable by 4 weeks. Madam for
Lordship, I am for 1 to 4.
MSMD Bora, Standing Council Transport Department accepts notice on behalf of respondents 1, 2, 3, and 4, whereas the Finance Department respondent 5 is represented by the Standing Council 3.
See, finance may defect.
B. Gogoi. Full stop. Let extra copies. Of the petition be served by tomorrow. As if finance be reflected in the cause list.
Deeply obliged.
Deeply obliged. Lordship, may I get a date, lordship, after 4 weeks?
4 weeks, you have said.
After 4 weeks, a date, lordship.
Let us see, let them come back.
File.
5 is similar.
Lordship, similar. This is also vehicle, but during the COVID-19 vaccination program. I provided vehicles, Lordship.
To whom, which department?
This is to Commissioner, DC and Commissioner of Police. Lordship, I kindly come to
Where?
case 14, Lordship.
This Kamrup district.
Kamrup district, ma'am.
Oh, Hertz, Sri TK, Mr. Leonard Counsel for the petitioner who by means of this petition has prayed for a direction for release of bills pertaining to supply of spare motor parts
No, Lordship, vehicles for COVID-19 vaccination.
for supply of vehicles. To
For
the,
spare motor parts, sorry, Lordship, sorry, I'm very.
you do not know your
I'm
petition,
confused.
we have to know. How, for supplying spare motor parts.
Lord.
Full stop. Oh. Para. Issue notice, huh? Yes, Mr. Bukolyal, for whom?
I'm 1 to 5. Okay.
3 G Bukolyal Leonard State Council accept notice on behalf of Sono 1 to 1
Five.
PO2, huh? 5. Aru, B Gogoi, huh? Names reflected, Mr. Gogoi? No. Names, this here, name of SC to be reflected on already. Yes.
I'm obliged, sir.
Give extra copies by tomorrow.
Lord.
I know. So pasta is na ito.
Page 50. Non-payment of bill. Page 50 is their admission. Page 50, question number 3.
The total outstanding bill. Okay. Railways, yes. Madam, we issue notice at this stage. Take instructions. We issue notice at this stage.
My lord, only one observation that pendency may not be a bar to release because we are making representations also to them.
Third, Sri M. Biswas Learned Counsel for the petitioner who by means of this petition has prayed for release of the contractual bills in connection with a contract agreement number SE/52 with the railways. Full stop. The Learned Counsel has referred to a communication dated 12/9/2023 received under the RTI Act to show that the amount involved is admitted. Full stop. Para. Let notice be issued. Returnable by 4 weeks. MSN Sharma, Learned Counsel, accepts notice on behalf of all the respondents. Let extra copies of the writ petition be served upon her by tomorrow. Full stop. Para. Pendency shall not be a bar for consideration of the representation of the petitioner, which, however, has to be done strictly in accordance with law.
My lord, in the synopsis, my lord, I put a gap, my lord. Only in the synopsis one date, my lord. I thought I would be writing it later, my lord, and it remained like this. The date of completion, it's there in the averments, but in the synopsis.
Let it remain. Yes, Averment is there. No, doesn't matter.
Averment is there.
Yes, next. 7 is similar.
Similar Lordship, I provided vehicle to COVID-19. Similar Lordship and admitted, liability is admitted Lordship.
Where? Where?
Page 3 Lordship.
Page 3.
Page 3 and, sorry, Annexure 3, page 17 and 18. 17 and 18. Also 19 Lordship.
TK Mishra, okay, for various contractual works, including submit, including for supply of vehicles.
Lost for
in-
COVID-19.
Including the supply of vehicles to the district administration during the COVID pandemic period. Notice, okay. This is which department?
Health.
MS S. Sharma,
1, 3, and
Learned Standing Council Health and Family Welfare. Accepts notice on behalf of respondent 1, 2, 3, and 4. 5 is Finance B. Gogoi, 6 is G. Bokolial, GA. Extra copies.
Lost.
Okay.
Also, may I take a date from my learned brother?
No,
After
no,
4
we are 4 weeks. Let them come back. It's
Look.
not that urgent. Let them
Look,
come back.
I am obliged. May I please, Your Lord.
Mullah, what is this?
Matter relates to non-payment of admitted amount of contractor's bill, my lord.
Okay, where is the admission?
My lord, page 22, kindly.
2-2.
Page 22.
Mr. Das, what do you say?
So we'll obtain,
Admitted.
sir.
Huh? What do you say about page 22? Okay, A. Howard Street, AFNU Mullah, Learned Counsel for the petitioner, who by means of this petition has prayed for release of contractual bills done with the APDCL. APDCL. Para. The
Petitioner's husband, my lord, now widow, petitioner, husband.
done
died.
by the husband of the petitioner with the APDCL, who however has passed away in the meantime. Full stop. Reference has been made to the communication dated 3/5.
My lord, page 22, my lord, 29/8/12.
But these are all bills.
Oh, my lord. My lord, he suffered 5 days bedridden period for 5 years bedridden period, husband, my lord.
No, from 2012 to 2023, what were they doing?
No, my lord, 29/8/2012, and then thereafter another communication 2014, my lord.
Then 14 till now, 9 years. How do you overcome?
My lord, they only assured, my lord, and it was not-
Then you sit tight. They have assured. Why have you come to the court after 9 years?
my lord, it was not within the knowledge of the petitioner. Now she is widow, my lord, and yes,
When did your your husband passed away?
husband passed away, my lord, 9/11/2022.
And there was no representation, nothing.
Representation is there.
Yes, where?
Representation, my lord, 12/4/2023.
These are stale claims, Mr. Mullah.
My lord,
2014, when was the work done?
work done, my lord, 12, my lord. Otherwise admitted, my lord.
What otherwise admitted? Admission when? What is the law of admission? What is the law of limitation? What is section 18?
Notice may go, my lord.
Why should we issue
She
notice?
is a widow, my lord, and
We are sympathy will is over. Can sympathy override the statutory provisions, the law? We are with you.
not only, they are already indebted, even they have taken loan for treatment of the husband.
Mr. Mullah, these are not going to make any difference to a court. We have to act in accordance with law. See the delay, it's not 1-2 years, almost a decade.
I have given the, my lord, the reason, my lord, paragraph 15, my lord.
Let us see what reasons have you.
Paragraph 15, my lord.
Yes.
The fact apostate non-payment has come to the knowledge of the petitioner after the death of her husband, my lord. And then I have, my lord, submitted representation. Bedridden condition for 5 years, my lord, and
5 years from 12 to when? 17 thereafter?
oh, my lord, 17 to,
Then from 14 to 17, what happened?
then, my lord, this communication, so many communications were
Where?
there.
Where? After 14, where is the communication?
No, after 14, my lord, there is.
Then
no
14 to 17, 3 years, what did you do? Your husband was there? See, sympathy is one thing, we will definitely
Yes,
have. But you cannot ignore the statutory provisions. Where is the statement regarding the death of your husband?
husband, my lord, I have given here. Next of kin,
That-
my lord.
That was on 9/11/2022. And you have filed this thereafter after more than 1 year from the death.
Records could not be traced out. So many files were there, my lord.
Say it again. Communications dated 3/5/2012. Full stop. Para. This court has, however, noticed that the works are of the year 2012 and the bills are more than a decade old. Full stop. The learned counsel has, however, submitted that the husband of the petitioner was unwell for a long period. Full stop. On a perusal of the pleadings, even that submission does not appear to be a reasonable one, as the health condition of the husband was not good prior to his passing away, which was in the year 2022. Full stop. Para. Be that as it may, let notice be issued, returnable by 4 weeks. 3B thus, learned counsel accepts notice on behalf of all the respondents.
Yes,
That
sir.
extra copies of the writ petition be served upon him by tomorrow. Para. Maintainability of this writ petition is, however, kept open.
Pending disposal was
Pending disposal, we want a dismissal. We are raising a question on the maintainability, and you are asking of a pending disposal.
published.
Yes.
My lord, my house was connected electrification, my lord.
What has happened? Yes, what is it?
My lord, the case is that my house was connected electrification. Also, the meter box has been taken away. And
What did you do? You must have done something very noble.
so, question
What
is
was
this,
your noble deed?
my lord, the question is this: that they impose the penalty.
What did you do to invite a penalty?
Question is, they impose the penalty, my lord, huge amount without.
What did you do? Why aren't you disclosing? You're shy of disclosing.
So, my lord, I have submitted a representation before the authority, my lord.
Again,
Last
you
page.
said, what did you do? What was the reason for this action?
Rejection there, they have stated, my lord, that
No, not they have stated. You have to state.
they are
What did you do?
thefting of electrification.
Huh?
They are pleased thefting of electrification.
Thefting. What is thefting?
They're thefting. They said thefting, my lord. Kindly have a look at.
Thefting. What
Kindly
is
have
this
a
new
look
word?
at, my lord. What is their
What is
theft
the-
by
what is-
meter bypass?
What is this new expression, thefting?
My lord, page 16. 16.
Dr. Saraf,
Theft by meter.
thefting, have you heard? We have heard of Threptin biscuits. Threptin. Not
Theft, my lord.
Okay, theft. Okay.
Theft. They are pleased theft.
Maybe it's a new vocabulary, we do not know.
Yes.
Thefting
Theft.
and theft.
Theft.
Okay.
Theft by meter bypass. They are pleased.
How did you steal the electricity?
My lord.
When did you steal? How did you steal? How was the theft committed?
They are telling the theft by meter bypass. My lord, kindly see their order. Kindly see their order. You will, lordship will see.
Page.
Annexure 16, my type copy, and Annexure 17 is their copy.
Not annexure, page.
Page, my lord, page 14, Annexure 4. Page 16, Annexure 4. Page 16, Annexure 4.
Yes, Caesar. This is the materials. You had bypassed the meter.
They said, but I did not do it.
What is your version?
Pardon?
What is your version?
My version that I have, since my house has been connected, I have been continuing paying my lord, the electricity bill with no area at all. So I have no fault on my part.
Mr. Pathak, is there a provision for appeal?
Yes, in fact,
When there is
What, 126, so what was?
127, appeal
What?
is under 126(3) and then
126.
another 127.
Yes. You can appeal before the authorities. Why a writ court? These are factual disputes.
My lord,
Whether your meter was bypassed.
so my question is this, my lord, I have come before your lordship on the ground that it's immediate effect because I am living in darkness.
Understood.
Without giving me any notice and informing me, my lord, suddenly they have come and took away meter and disconnected my house. So I'm in darkness, my lord. So immediate result, my lord, I have come before your lordship. So
When was it disconnected?
my lord, I am disconnected, my lord, on 3/11, my lord.
311.
3/11 of this month. 3/11.
Take no,
311.
instructions.
So otherwise, the mandate of the act is once sector of electricity is covered, we have to immediately disconnect the electricity. That is
Okay.
what the act.
Now, well, how do you, what are the remedial measures?
Then
How much fine?
the, I'm sure an assessment bill has been served upon the petitioner, Lord.
Nothing,
If the
nothing
amount
has
is
been served,
paid,
my
then
lord.
it can be restored forthwith.
What is the basis of the violation of section 135 of the Electricity Act? My lord, I have gone through. There never has issued any notice.
1,08,000.
My lord, firstly, my lord, see,
1,08,000.
firstly, they have imposed, my lord. It is very surprising, my lord. Firstly, they have imposed 1,56,000 by morning, by 11 a.m. By 12 a.m. Noon, they came again. Yes, it is wrong. Now they have rectified it to the amount of rupees 1,08,000.
Yes.
So their assessment is puzzled, my lord. Assessment is puzzled. Morning they are doing one thing, by noon they are doing the thing, by evening they are doing the changing their.
It's been reduced. It's good for you.
Not that, my lord. So it is their wrong assessment.
The wrong assessment has, in fact, is beneficial to you.
Question, my lord. Good.
From
Day before yesterday.
1,50,000 has come to 1 lakh.
My lord, I have.
How much amount are you going to pay?
My lord,
Deposit.
my lord, I am very poor personal lady, my lord. I am a widow lady, my lord.
What do you do?
Now I am widow lady, my lord. I am just maintaining my son and my daughter is earning, and they are maintaining, my lord, my family. So a little amount may kindly be pulled, my lord.
No. What do you do? What does your son do?
He's a day laborer, my lord. He's a day laborer. I am a widow, my
Where
lord.
have you stated? Where have you stated?
My lord, I am a widow lady, my lord.
Where have you stated?
I am stated, my the petitioner vector state that they are taking
Where?
much trouble without electrification. Now that I have not mentioned, my lord.
Then-
I am a widow lady, my lord.
Where? How do you know? You are saying will not do. Where are the pleadings?
Statement has been made in a synopsis. Apart from that, there is much.
In the pleadings, what have you stated? What is your income? What do you do? You are below the poverty line.
That I have not mentioned, my
Then-
lord. I am a widow lady, my lord. I am the beginning. I have said, my lord, I am a widow lady. My lord, income I have not mentioned, my lord.
Where have you stated you are a widow?
My lord, in the synopsis I have stated.
Synopsis is not pleadings.
Synopsis I have stated.
Synopsis is not pleadings. You have said nothing.
In the synopsis I have stated, my lord, the humble petitioner is a very poor widow lady. On the first synopsis, my lord, I have said.
You are a poor widow and lady also. Okay. No, short notice.
Short.
You take instructions, you pay 50%, we'll direct
But the
restoration.
mandate of 135 is that it has 100% has to be paid.
I know, but
No, my lord, electrification, my lord, they have not given me the notice, no information. Suddenly they have come to my house with a
under what provision notice is
They
required?
have issued under 135 electrification.
No, under what provision notice is required? Show us.
They have said 135. Now question,
Now, under what provision you say notice is
my lord, the 135 said that information should be given.
yes.
And electrification, cutting of electrician, there is some rules. The assessment
Show
of
us.
fine,
Show us.
see, the assessment of fine is there, my lord.
Show us. Which rule?
On what basis they have assessed this amount? Law does not mention anything. They directly invoke this fine. Law says the assessment should be made firstly.
You take
10
instructions.
amounts.
You take instructions. How much amount you are willing to deposit?
So, my lord, I'm ready to pay, my lord, 30,000. My lord, I'll pay now.
30,000.
30,000, my lord. Imposing fine is illegal, my lord, so much. I'll ready to pay 30,000.
That part we'll examine. your demand is more than a lakh rupees, you pay 50%. These are electricity charges. Rest, that will be, we'll see. Otherwise, the statute requires 100% deposit.
My lord, they kindly make it 40%, my lord, I'll pay. Kindly, my house is, I'm in darkness, my lord, they have cut down the electricity, my lord, they took away the meter box, my lord. 40% I will pay, my lord, with all the due respect. Kindly reconnect it, my lord. I'll pay.
We are nobody to reconnect. We're only here to do something which is feasible
Give
under
a
the law.
condition, my lord, I will pay 40% now. They should allow me to reconnect it, my lord.
Rather
Thereafter,
than that,
thereafter, as for law, the assessment will be made.
What do you suggest?
because the mandate is because might set a precedent, what I would like to
No,
submit
it's
is
not cite a precedent. But whatever is it, what is the
if
suggestion?
the petitioner pays the entire 100%, get him paid over 3 installments over a period of a year. Or
No,
4
but
installments.
the matter has to be adjudicated.
Perhaps for on the ground of
If
adjudication.
not
of
asked, at least by the authority, because your demand, he is raising a dispute. Matter has to
that
be
has to be
adjudicated.
decided on by the authority empowered under the act. On merits.
You restore the connection. See, it's not possible without electricity. We'll direct him to deposit 50%.
Right.
Okay.
But Lordship may kindly make an
Obviously,
observation that it's not a-
obviously, it's only the facts of the case. Third, Sri H.R. Khan, learned counsel for the petitioner, who is aggrieved by the action of the APDCL in disconnecting the electricity connection to her residence and also imposition of a penalty of rupees 1,08,000. How much? 1 lakh.
presently it is.
Presently, it is 1,08,900.
1,08,966.
66.
108,966. Full stop. Para. The learned counsel has submitted that the allegation of theft is incorrect and therefore and further that the disconnection was done without any notice and a huge amount has been imposed as penalty. Full stop. Para. Per contra, comma, 3. AP Pathak, the learned standing counsel of the APDCL has submitted that matters of this nature cannot be the subject matter, cannot be the subject of adjudication under a writ court as there are factual disputes. Full stop. He has also placed section 126(3)
126.
of the Electricity Act 2003 and has contended that there is a provision for appeal
Objection.
or a provision for filing of objections against such section, which and if further aggrieved to prefer an appeal under section 127. Full stop. Para. Be there as it may, comma, let notice be issued returnable on 10th of January. Sri Pathak, the learned standing counsel, accepts notice on behalf of all the respondents.
All the response.
All the respondents. Para. Sri Khan, the learned counsel for the petition, appraised for an interim order and has submitted that without the electricity connection, comma, immense hardships is being suffered by the petitioner and her family members. Full stop. Sri Pathak, the learned standing counsel, however, submits that the petitioner may be directed to deposit the amount in question, after which such connection may be made. Full stop. Such connection may be directed to be restored. Full stop. Para. After hearing, comma, this court is of the opinion that balance of equity would be served if the petitioner is directed to deposit 50% of the penalty amount, which comes to rupees. What is 50% of 18966?
1,50,854,000.
Not 1,56,000, 1,08,966. What is
It is
50%?
50%, my lord, it will be 54,000.
54,000. How much?
50,966. Like that.
Make it a round figure. 50%, which is rounded off to rupees so and so.
54,400.
54,500.
400.
54,000, which is rounded off to rupees 54,500. Full stop. Such deposit may be made immediately by the petitioner before the authorities, and on receipt of the deposit, the electricity connection is to be restored without further delay, without any further delay. Full stop. It is, however, made clear that the aforesaid direction is without prejudice to the rights and interests of the parties in dispute,
Leave it all right.
But I was
and would be reconsidered on the returnable date.
but I was waiting for response numbers 2, 3, and 4. 1 data was time as submitted part.
One G Bokolial State Council, no? 2, 3, and 4. If go to board, extra copies.
I will give.
That to portal here extra copies too. Okay.
Apply.
Mr. Sharma, what is this?
The matter relating to not refunding the security deposit amount to the petitioner,
Public Works.
public work.
I thought my please to issue notice.
Okay. Heart Sriti Sharma learned counsel for the petitioner, who by
Lordship,
means.
one thing, Lordship, may I stop in, Lordship? Executive engineer has already prepared the bill and submitted before the chief engineer. Already, only the amount is not stated. It is admitted, Lordship.
Let him have the notice.
Sure.
Heart Sriti Sharma learned counsel for the petitioner, who is aggrieved by non-refund of the security deposit pursuant to the two works, pursuant to the following two works. Synopsis of Xylem, huh? Following two works. Let notice be issued, returnable on. We give a date.
Yes.
Returnable on 12th of January.
Well.
3. You are standing counsel or on behalf of Mr. Gogoi?
On behalf of Mr. P. Gogoi.
Okay. What did you say your name?
H. Good. H. Good.
H.
Borua.
Boru. Okay. I'm totally H. Boru and counsel appearing on instruction of Sri B. Gogoi, standing counsel PWD, accept notice on behalf of all the respondents.
All the right.
Extra copies.
If the petitioners are license holders of a fair price shop, and the license was suspended in the year 2022, July 2022.
Okay.
Thereafter, the show cause notice was issued in October 2023, after more than 1 year.
After more than 90 days. Okay.
More than 1 year, Your Lord. I have responded to the show cause notice as well, and there is a report from the inspector that since this is a minor offense and the first offense, it may be continued. Thereafter, nothing has been done.
Okay. You are still under
Under
suspension.
suspension for more than
It
1 year.
cannot remain under suspension. I am very concerned. A order from 15. $15, is it? 15.
15 2 years.
You restore it. Or we do one thing, we'll have it on the reopening, because we not know these are the facts projected. If something has been done in the meantime, okay. Heart Sri B.J. Mukherjee, learned counsel for the petitioners, petitioner, full stop para. The petitioner is a license holder of a fair price shop in the district of Hujai. Full stop. Wide and order dated 8/7/2022. The said license was suspended, and after a period of more than a year, a show cause notice was issued on 12/10/2023. Full stop. It is the case of the petitioner that after filing of the response, comma, there has been he has been informed that there is a move to allow the petitioner to continue as the offense in question was found to be a trivial one. Full stop. However, comma, till now, no action has been taken to permit the petitioner to run the fair price shop. Para. Let notice be issued, returnable on, we fix a date, Mr. Bukulian, returnable on 10th of January. 10 January? All the respondents?
All right.
Sri G. Bukulil and the State Council accept notice on behalf of all the respondents. Extra copies. Para. Sri Mukherjee, the Learned Council prays for an interim order. Full stop. Clause 15 of the Assam Public Distribution of Articles Order, 1982 lays down the provisions of suspension and cancellation of fair price shop license. Full stop. It is the mandate of the statute that an order of suspension without notice cannot continue after more than 90 days. Full stop. Para. The aforesaid aspect of the matter will be considered on the returnable date. Okay.
Pendency may not be a bar for them.
Para. It is further observed that pendency shall not be a bar for the authorities to restore the license, or no, restore, no, to restore the license of the petition in accordance with law. Item 12. What is the matter?
Gosala Lottery seeking permission for taking care of the cattle. As
Okay.
per Assam Cattle Protection Act 2021.
Mm.
So, before going to the-
We'll issue notice at this stage. We'll issue notice. There cannot be any interim order in this.
That's it, Section 20 of the Assam Cattle Protection Act.
No, see, you have not prayed for, there cannot be an interim, we are issuing notice. Is your senior around in the court? Is it,
Yes.
I think we record his name then? Heard Sri H.R.A. Chaudhary, Lunch Senior Counsel, assisted by Sri, is it Ahmed? Is it Ahmed? Full stop. The petitioner is a registered society. And has approved this court to permit the society to run a Gosala in the district of South Salmara Mankachar under the provisions of the Assam Cattle Preservation Act 2021. Full stop. Let notice be issued, returnable by 4 weeks. Animal has been in veterinary. Kotoki. Ki Kotoki is it? Kotoki. Is he around in the court? MM Kotoki. He served on প্রথমটা এসে লিখবে। Three, M. Chetia, London State Council accepts notice on behalf of respondent number 3
and 4, my lord.
3 and 4. Full stop. This court has been informed that the Animal Husbandry and Veterinary Department has a standing council, M. Kotoki. Full stop. Let Kotoki, who would accept notice on behalf of respondent numbers 1, 2, and 5. 1, 2, and 5. Para, let extra copies, huh? Have extra copies. Name shown or not? Let the name of SC, AHN, Veti be shown in the cause list.
Postpone one date.
4 weeks. Not that important. Okay. Yes, Dr. Saraf, what is this?
No, right from against the blacklisting order,
Huh?
order
Oh.
for testing blacklisting.
That is the subject matter of challenge.
Challenge.
Okay.
And you also find that I will demonstrate you also that the primax is illegal.
Who's for the
So
respondent?
this is BPCL, I found that no standing on.
Union of India is there.
In India, we have such copy.
The blacklisting is by BPCL.
BP. Now,
Okay.
what happened, my lord?
Let us see the blacklisting order.
My lord. You'll also find that order.
Page.
I'll just give you that. The testing order will be at page 372.
372. Yes, please. One year.
1 year.
It was preceded by a so-called notice.
You know, the so-called notice was on some other issue, my lord. And, you know, what I'm saying, my lord. The tender was, my lord, for 15 crores. Now, the purchase order that was issued was for 12 crores. And the release order was issued for 5 crores.
What order was issued?
The release order. for
Release order, okay.
That was issued for 5 crores. We supplied for 450 crores, 4.5. And we requested again and again that kindly allow the balance also to be released. They have not released the order.
Okay.
Now, the purchase order which was issued for 12 crores, the 7 crores, they have also not placed the order. Now, the letter of intent was for 15 crores. Now, we said, because the time was the issuance of the contract, my lord, that within 12 weeks from the date of the issuance of the letter of intent, the goods had to be supplied. Now, 12 weeks have passed long back, my lord, that was in January 2023. Now, we said that because the price, my lord, which we quoted, that cannot remain firm for the 2 years. So we said that 12 crores will supply whatever purchase order was there. The contract price and the LOA, work order, that was 3 crores. It might be difficult for us to supply because the order was not placed. Now, if the contract breach is there, that can be only when I'm asked to supply the goods and I'm not supplying. Purchase order was for 12 crores. That has also not been allowed to be supplied. Release order only for 4.5 crores. And they are saying that since you have said that 15 crores was the, well, the tender document and 12 crores is only the purchase order, the difference you will not be able to supply, you are blacklisted. Well, a breach of contract can only be there when somebody is asked to supply and he fails to perform the duty.
You are not against the cancellation order or the contract as such. You are only aggrieved by the blacklisting.
Look, they have not cancelled the contract. They are simply saying that we blacklist you. Now, blacklist you because we lot the 12 crores, we are ever ready to supply the goods. They have not allowed us to supply the goods. And on the other hand,
No, see,
yes,
Mr. Dr. Sir, if you know our limitations, in a matter of this nature, we'll go whether the decision-making process was done by following the due process. Here, Eurocent Chemicals, Equipment, then Raghunath Thakur, everything has said that.
all the judgments you will also take with.
Yes,
But
but whether you are given a fair opportunity to present your case before the blacklisting, because it has got adverse civil consequences.
You are also similar, the last one, but paragraph.
Yes, we have just sitting, hence after considering.
In view of the above, it is noted that against fulfilling the contractual obligation of supplying about 12 crores something worth of the price of goods.
Where are you reading?
Below that page 372,
Yes,
last but one paragraph.
a view above, yes.
In view of the above, it is noted that against a fulfilling the contractual obligation involving 12 crore something worth of MDB pipes against the contract, Mr. Mukund so-and-so, product confirming,
Can you serve dusty upon the respondents?
you can serve.
Serve dusty.
But what is the problem? That this blacklisting order, for so far as supply in this concern, there is no difficulty. But there are various tenders which are last date 25th. Now, I will not be able to participate in those tenders. Now, assuming, my lord, after 10 days, this order is set aside. I will not be able to participate in those tenders also. I don't. And that will have an effect of 5 years. Because today the tender process is there. And you also see it absolutely incorrect, my lord. That 24.5%, whatever they are saying, that is between 15 crores and 12 crores. Nowhere I've said that I will not supply 12 crores. I've never said. I said, my lord, the difference between 15 and 12, that is contract value and the, my lord, the purchase order. The purchase order was only for 12 crores.
We cannot go to the merits of the
I'm not
dispute.
going. You're asking me the so-called notice.
If you read the last paragraph of 372,
My lord,
hence after considering the contentions made in the show cause notice
my lord.
and your reply to the show cause notice as cited above, it has been decided that business dealings with you and your allied agency will be banned for a period of 1 year.
You're asking me to see the so-called notice 339,
339.
339.
Yes, please.
In the first, at 340, my lord.
Should not be placed on a holiday list. This is specifically on blacklisting.
No, my lord, the blacklisting is there, but what is the reason? For what? You're asking me, I saw the judgments.
We'll consider an interim prayer on the returnable.
My lord, but my lord, you're asking me just, my lord, because this
Prima facie, we are not with you.
my lord, I prima facie, I'm showing that, my lord, that this is a case. Because you're asking me.
See, on the merits of dispute, we are not going.
No, my lord.
We are only on the part of
My lord, the question-
procedural.
my lord, if you also find that the so-called notice was for something else and the final order is something else, your lordship will certainly stay. Your lordship, the what they are saying in the so-called notice that I said that contract value and purchase order, the difference I will not be able to supply. In the final order, they are saying that I have said that I will not be able to supply the contract value, the purchase value. That is not correct. In this so-called notice, they say, my lord, that the difference between the contract value and purchase value, I will not supply.
You served them on the reopening. We'll consider 4th.
My lord, just my lord, lost me see, my lord. I'm not concerned.
Today.
My lord, I'm not concerned, my lord. I'm not concerned with the
25th, there may be some tenders. There will be tenders later on also. That is not
my lord,
going to influence.
you're asking me kindly, my lord. 25th and all these things tenders are there, and that will have effect of 3 years because the purchase, my lord, supplies. My lord, it will account to, my lord.
The blacklisting is for 1 year.
My lord, blacklisting 1 year will not be sufficient, my lord. I am not concerned with this blacklisting. I am not concerned with this BPCL. My lord, this will have an effect on other tenders.
Which tenders?
Other tenders which have to submit 25th and last. If you lordship observe that this,
25th, it's not that all the tenders are going to come to an end on 25th. There will be no works.
well, this lordship observe that this blacklisting order will not come into way in submission of other tenders. I will not difficulty, my lord. This blacklisting order will not prevent the petitioner from submitting the tenders in other, my lord. Otherwise, it will be closing down the industry.
We do not know where you are, because this blacklisting is not only confined to BPCL. This
It says BPCL and entities, BPCL.
yes.
But other tenders, it mentioned that whether you are blacklisted in other some concern.
Exactly.
So, my lord, if
The concept of blacklisting is not only qua the unit entity which has passed the blacklisting. It will be in relation to all other tenders.
With this company, I can understand. With this company, BPCL, I can understand.
No, Mr. Dr. Sarab, that is not the purpose of blacklisting for only one company.
Well,
Blacklisting is for the purpose that we are not accepting for a moment what the respondents might say. You may be 100% correct, but the objective is to make the other similarly situated persons aware that this is an entity which has not performed well, so we are blacklisting.
Well, I fully agree. Well, lost my
That cannot be for one entity.
Well,
It is for all.
Just appreciate that this order after 10 days will not be set aside by law on the grounds. Now, within these 10 days,
whatever
No,
petitions.
if it's set aside after 10 days, you will get chance in other contracts.
So the tenders which are
26
there.
is not that case, that
My lord,
26 all tenders will
that
be
is
over.
that is the only intention, that I should be debarred by the competitors, my lord, that I should not be able to participate in other tenders. My lord, that you lost me.
No, Dr. Saraf, all tenders coming to an end on 25th, there will be no tenders after
My lord,
25th.
the tenders which are there in 25th, that will have an effect up to 3 years, the supply.
No, won't there be any other works after 25th?
My lord, 25th, the tenders which are there, they are large tenders. and that, my
Maybe,
lord,
these are not the only tenders you can say.
my lord, in the business, my lord, if I am manufacturing and 3 years I will not be able to participate, my lord, you lost me, kindly see, my lord, private.
Where are those tenders on 25th?
Well, I was stated in the
Where-
petition that
where?
25th is the last date.
Where? Which
In the-
tenders?
I have not given the details. I have given, my lord, that 25th is the last date.
Where have you stated?
Well, I have stated, I am just, my lord. At the petition page.
See, we see that Eurasian equipment chemicals have been complied with, Raghunath Thakur complied with. Prima facie,
Well, so-called notice and the order is not even the same. And the judgments of the Apex Court I have placed before Lordship, my lord, that the Supreme Court has said that it must be unambiguous and clear. My lord, that is para 37,
page
page 48.
48. Yes.
Some of the tenders procured by the other entities have the last date of submission on 25/12/2023, and the petitioner shall suffer loss in injury in case the impugn orders for instance, the prime minister not state. But
Not enough.
well, I place before Lordship some judgments, if your Lordship permit me.
Yes, please.
Although your Lordship is very much aware, but still then,
Which one? Any new judgments? These are all,
you know, the all judgments, these judgments are only repetitions, my lord.
these are all known.
You know, something which is in the so-called notice. If the so-called notice which is there, you'll also look into all these judgments, but even then, my lord, you'll also see page 200, page 6,
Of this compilation,
compilation, my lord,
please. UMC,
my lord.
UMC, this
13, my lord, para 13 at page 13,
paragraph 13.
my lord.
Yes.
At the outset, it must be noted that it's the first principle of civilized jurisprudence that a person against whom the action is sought to be taken or the right or interest are being affected should be given a reasonable opportunity to defend himself. The basic principle of jurisprudence is that before adjudicating fact, the authority concerned should give the affection of the case against him so that he can defend himself. Such notice should be adequate and grounds necessitating action, and the penalty account proper should be mentioned specifically and unambiguously. An order traveling beyond the grounds of proper notice in impermissible and without jurisdiction. And thereafter also we see, in so-and-so it has been held, it is essential for the notice to specify the particular grounds on the basis of which an action is proposed to be taken so as to enable the notice to answer the case against him. Now, para 14 below, specifically in the context of the blacklisting of a person or an entity by the state or the state corporation, the requirement of a valid, particularized, and unambiguous so-called notice is particularly crucial due to the several entities being blacklisted, so and so. Thereafter, also skip on para 16. The severity of the effect of blacklisting and the resultant need for a strict observance of the principle of natural justice before passing an order on blacklisting are highlighted in so and so. Will also may thereafter come to para 18. This court in Gorkha so and so
Yes.
has described blacklisting as being equivalent to the civil death of a person because blacklisting is estimating in the nature and debars a person concerned so and so. Now, if it is a civil death, my lord, after death of the person, my lord, whatever we survive, whatever is done, that will not come. And whatever, my lord, if something has been done beyond the so-called notice, if something was there in the so-called notice, something else,
You read this, the paragraph thereafter,
my lord,
which has been quoted. It is a common case.
in the common case, the party that blacklisting has to be proceeded by a so-called notice. Law in this regard is firmly established and does not even demand much simplification. The necessity of compliance with the principal naturality by giving an opportunity to person against whom the action of the blacklisting sought to be has to be valid and solid rationale behind it. With the blacklisting, many civil and other legal considerations follow. It is described as civil death of a person who is posted with the order of blacklisting, which order is stigmatic in nature and debars such a person from participating in the government contract, which means precluding him from the award of the government contract. In the light of the above decision, it is clear that a prior so-called notice granting a opportunity of the hearing is an essential requirement. And I may take it another, I will take you to the another decision below at page 24.
2-4.
Paragraph 16 at page 24.
Yes.
The department cannot table beyond the so-called notice. Even the grounds apparent these points have not been taken. You cannot go table beyond the so-called notice. And the so-called notice, that the ground was that the difference between the contract value and the letter of intent.
Yes.
Now here you are saying that I have said that the letter of intent goods I have not supply. That is not absolutely incorrect from the so-called notice itself. You will also further similar the decision of the decision of the Jharkhand High Court, and you will also kindly see page 37, the relevant part. In the middle, Miller, from the
No,
finding,
the other decision which you have just read, that Tokyo decision,
my lord,
the Toyo engineering decision, is that on blacklisting?
Toyo,
That is not on blacklisting. Is it on blacklisting?
that is, I have placed it on the ground of, my lord, that the 1924, you lost me see, natural justice, my lord, at page 24.
24, paragraph 16 you have placed.
But I am only placing that one cannot table beyond the so-called notice.
No, so-called notice is pursuant to what? So-called notice
Well, any so-called notice.
regarding what?
Well, this is the case of excise.
No, so-called notice, qua termination, qua
This
dismissal,
was against the
qua
customs.
rejection, or
This was against customs, but the judgment which I placed before lordship, that was for blacklisting, and it is clear that one cannot proceed beyond the so-called notice. Well, if somebody gives a so-called notice, and
see
I mean,
that part you may be correct, but can you adjudicate or come to a prima facie finding that the conclusion arrived at are beyond the
well, if I can, I'm primarily demonstrating the lordship that the
Mr. Dr. Saraf will consider on the reopening. Will say something. Hard Dr.
well, that is
Saraf.
also that is a 50 crores below the tender is there, and that
Hard
will be invalid.
Dr. A. Saraf, Learned Senior Counsel.
Plus,
for
the
the-
I miss a minute,
Yes,
Also-
please.
although yeah.
No, please.
Well, my submission for that your lordship may, I criminal lordship will hear it and till with the tender, I may be able to, I may be allowed to participate. Ultimately, if your lordship dismisses it, I will not be my tender may be rejected. But I may be allowed to participate at least, Miller. Otherwise, Miller, my tenders will go.
Let us see what we can. I heard Dr. A. Saraf, Learned Senior Counsel for the petitioner, assisted by who is there? N.N. Datta, by Sri N.N. Datta. Full stop. The petitioner has put to challenge an order dated 8/12/2023 by which the petitioner has been blacklisted for a period of a year by the respondent authorities. Full stop. The senior counsel has submitted that though the impugned order was preceded by a show cause notice, comma, the allegation itself are unsustainable and goes beyond the terms of the work in question, full stop. It is submitted that the work which was for supply was itself ambiguous and there were lack of clarity from the respondents for which the supplies could not be made within the stipulated time.
No, my lord,
Though
supply has been made,
uh,
supply has been made, they have not placed the order, released the order.
the total supply could not be made, full stop. It is however submitted that out of the total supply, comma, whatever orders has been placed have been fulfilled by the petitioner, and it is for the default of the corporation itself that the impugned action has been sought to be taken, full stop. Para. Issue notice returnable on 5th of January 2024. Anyone CGC? Anyone CGC? Central government. K. Gogoi. K. Gogoi Leonard CGC accepts notice on behalf of respondent number 1. Steps for service of notice upon the respondent numbers 2, 3, 4, 5, and 6 be taken by registered post with AD. Can you serve Dusty?
Sure.
Mumbai.
So I can send by mail if you lost copies of the
Okay.
trustee and send.
Okay. A service upon the said respondent numbers 2 to 6 is also permitted to be sent by email on their official email ID. Full stop. Steps by tomorrow. Full stop. 3. The Dr. Saraf, the senior counsel, prays for an interim order. Full stop. By referring to paragraph which paragraph?
32.
32. 32 of this petition. Comma, it is submitted.
I'm sorry, 37.
It is submitted that there are many works in the offing. The last date of and in case of some of the works, comma, the last date of submission is 25/12/2023. And if the impugned order is not stayed, comma, the petitioner would suffer irreparable loss and injury. Full stop. Para. Consider the aforesaid submission. Full stop. The requirement of law as laid down by the Honorable Supreme Court in a catena of decisions, including the landmark judgment of erosion equipments and chemicals reported in so-and-so, is that the action of blacklisting having adverse civil consequence, comma, an adequate opportunity is required to be given to the affected party, full stop. In the instant case, however, it appears that the impugned order dated 8/12/2023 was preceded by a show cause notice which was replied to by the petitioner, full stop. Though submissions have been made on the correctness and legality of the allegations as such, comma, at this stage, this court is of the view that it may not be proper to go into that aspect of the matter without hearing the other party. full stop. This court is also of the view that though the last date in some of the tenders is fixed on 24/12/2023, those cannot be the only tenders, only contracts where the petitioner would be interested, full stop. Be that as it may,
My lord, if your lordship,
be that as it may, the interim order, the prayer for interim order is not declined, which would be reconsidered on the returnable date in presence of the respondents.
again, the petition, my lord,
Yes,
I may be allowed to participate, that the result will be subject to result, whatever orders you pass it, the lordship pass. I
Sure.
want to be debarred at least from participating, my lord.
no, sorry. That we can pass for rest on 4th, on 5th.
Item 46 of this.
Lordship, let this matter be taken after some time. My seniors would like to.
What is the matter about?
Matter pertains to Lordship. A contract which has been settled with me is relating to the Assam Tourism Development Corporation.
Okay,
And I have been settled with this running and developing a newly constructed cluster, which is known as Panbari Basbari cluster at Manas National Park.
okay,
The Lordship goes and sees the letter, the first annexure 1,
yes,
which is the detailed notice inviting bid.
okay.
So your Lordship will see,
What is your cause of action?
my cause of action is that without show cause, my allotment has been cancelled. My allotment was for 15 years, and they give a reason where your Lordship will find the reason being at page 150,
150.
last annexure 15. This is the starting part of the letter
Yes.
addressed to me on the top to Pankaj Chaudhary, the petitioner, wherein the Lordship will see the subject development operation management contract for running the newly constructed Panbari Basbari cluster at Manas National Park.
Okay.
Here Lordship will turn to next page, where your Lordship will come to the middle part, para 5.
Yes,
Para 5, if I read it slowly, your Lordship,
yes, yes.
that pursuant to notice inviting bid, you had participated in the tender process, and among all the documents submitted by you, an agreement dated 15/1/16 was submitted to prove your credentials pertaining to experience in running a registered hotel, guest house, resort, having restaurants and F&B services for minimum 3 years. Such agreement dated 15/1/16 was shown to have been executed by you with Birina Tourist Lodge. In the said agreement, it has specifically been mentioned that the first part is the absolute owner and possessor of Birina Tourist Lodge. Thus, as per the agreement dated so and so, you are not the owner or proprietor of Birina Tourist Lodge, but another document, that is a trade license submitted by you, shows you as the proprietor of Birina Tourist Lodge. That is the bone of contention, your Lordship.
Okay.
Then coming next, your Lordship, being suspicious, the ATDC wrote an email dated 4/5/2023 to Birina Resort within a request for confirmation that the aforesaid agreement was duly executed. In reply, Birina Resort, by email dated so and so, stated that they have not come in terms with any party for any such. This agreement is unlawful and herewith void. This is totally vague, your Lordship. If I may read further, thus Birina Resort has confirmed that they had no terms with you and the agreement dated so and so is unlawful and void. Then coming next, your Lordship, that ATDC has given a show cause notice, which I dispute, Lordship. That is, I have never received it. This show cause was never received by me. To clarify and justify a position with regards to allegations against you, you could not provide any satisfactory reply.
This is 1st of November.
Yes, your Lordship.
We can issue notice now.
Lordship, and because no, Lordship, some development has happened, your Lordship turns to page annexure 11/138. Fresh tender has been issued, your Lordship.
Okay, you participate there.
Lordship, no, my participation, because I have submitted my bid document, LOI has been issued. I have started my work. Lordship will kindly see the photograph.
Now they have found that you have misrepresented.
No,
by
your Lordship.
stating that you
Lordship-
are the owner of the Birina Lodge. You
No,
are not
Lordship,
the
Lordship will
owner.
kindly come to the agreement, Lordship. Kindly for a moment. The agreement which has the lease agreement,
Page
page 71.
71.
71.
Yes.
This is the lease agreement.
Yes.
This is the lease agreement between Birina Tourist Lodge and Pankaj Chaudhary. That is the petition, your Lordship.
Yes.
The second part, lease. My specific case is that I am a lesser. I have never said.
Let
And
us
there,
see
your
the
Lordship,
agreement. Let us see the agreement
agreement, yes, your Lordship.
with you and the
Birina Tourist Lodge.
no, not Birina, with Assam Tourist.
Yes, your Lordship.
ATDCL.
LOI,
Tourist Lodge.
118, your Lordship.
100?
118,
118.
118. the letter of intent.
Yes, please.
This is the letter of intent. And Lordship, there are very much lot of discrepancies here in this contract because I say the letter of intent, if I may take your Lordship, the letter of intent they have first issued on mere 8th February, after 6 months. The tender management committee.
Mr. Mohanto, the impugned order
Yes, your Lordship.
refers to what?
Refers to,
It's 150, isn't it?
yes, your Lordship.
What is the discrepancy they have noticed?
Discrepancy, they say the trade license.
With, as such, agreement was shown to be executed.
Agreement says I'm a lessor. Agreement nowhere says that I'm the proprietor and rightly given by me, saying that yes, I have run. Because the eligibility criteria, if your Lordship is in the tender document.
Where is the, again, the agreement page?
Page 71.
Yes. 15 day
Deed of lease agreement. 15 day of January 16. Date may be noted, January 16, your Lordship. Nowhere I have said, your Lordship, that I am the proprietor. And that email, your Lordship, does not say at all to whom the email was sent, which current year they are asking the information. Just a mere statement will not.
Where is the trade license?
Trade license, Lordship, page 70.
70. Yes, what do you say?
The beginner twist those metal proprietor concourse for people.
No, but this lease agreement at page 71 was also given to you. At page 71. It says that Birina Tourist Laws is the first party. Isn't it? And Pankaj Chaudhary is the second party. Correct? So if Pankaj Chaudhary is the second party, your narration at 151 appears to be incorrect. Page paragraph 5.
From I don't have confirmed that they have no terms with the agreement. Same agreement in one.
Page, where is that page?
Yes, my lord, 71, my lord.
That does Birina has confirmed that no terms.
No terms, sir. Birina is confirmed that they have no terms.
We see Birina. Where is that email 55-2023?
Oh,
Do you have a copy of the email 55-2023?
to whom it was sent, who was the manager, on what authority he has replied, what was the email.
No. Thereafter, what happened to the so-called notice?
Lordship, they did not give us any opportunity. They've cancelled it. This
No, paragraph 6.
Paragraph 6, my lord.
yes, that has never been served to me, your Lordship. That show cause.
As far as my lord,
Just a
they
minute.
failed to justify my lord, their position.
Page 130 is the notice which I have received. 130 of the Lordship sees, that is in regard to a different project. And this what they have referred to in page 151, 1401, that I have never received. 130. This is regarding to Lakhi Bazar, Sumbagan. This is a different contract. That is the only notice I have received. They give a so-called notice giving reference to Lakhi Bazar, and at the end, the same so-called notice, at the end part, Lordship will see. At the end part, so-called notice, page 133, the last. This project stands cancelled. They give a notice for a different contract, and 133, the last part, they say you may submit your so-called reply within 7 days from receipt of this notice, failing which your contract for so and so Panbari Basbari cluster as Manas National Park stands 10.
What was the date of this contract?
This contract, Your Lordship, it was LOI was given on to me on 8 February 2023. 8 February 2023.
And present one?
So this is the present work which I am doing.
No, 8 February is also this contract.
Yes, Your Lordship. Two works, Your Lordship, because in the notice inviting tender, there were two bids. Your Lordship will see page, annexure 1, page 25, two package,
No, you come to page 131.
121.
131,
131,
paragraph 2 towards the last part.
Yes, sir.
ATDC wrote email dated so and so, Birina reserved a request to confirm Birina 55 stated that not in terms, you have deliberately forced. This is Birina.
Lordship. No, regarding the contract, I'm saying, Lordship, two contracts.
No, two contracts, but the contents of this so-called notice
Yes, Your
at
Lordship.
page 130
Yes, Your Lordship.
is in connection with Birina law resort only.
But for a different project. Birina, two packages.
Doesn't matter if you are having a contract agreement with
Yes.
Birina, which was the basis of a contract.
Right.
And that is also taken care of at page 131, middle paragraph.
Yes, they say, and for that I reply.
What is your
saying-
reply? What is your reply?
My reply on the next page, Your Lordship.
Page
Annexure 9, 134.
134. What do you
Yes.
say?
As to the general manager, reply to show cause. For this, I have replied. It says, with reference to subject, I beg to state that the allegation made against me in your above mentioned letter are false, not at all based on proper evidence. I will prove my innocence in this regard with evidence. But I will take to which time to submit the evidence as condition of my father's that is not good for some time. He is aged about 75 years. Besides, out of what is not doing well for last few days, I seek time of 2 weeks, Your Lordship, in this letter. Then subsequently this notice, next page, annexure 10, page 135. This cancellation notice is issued. Twice they issue, Your Lordship. On 8 August, the date needs to be marked, Your Lordship. On 8 August 2023, prior to I file a representation seeking review of the decision. This is the cancellation notice on 8 August.
Well, examine at this stage notice only.
Status quo maintain, Lordship, kindly, Lordship.
No.
Because, Lordship, I have.
Let them
lot of-
come. Let them come if they will say something. If they go ahead, it will be
Not be
subject to the
decided
outcome.
at this final call may not be taken, Your Lordship. My humble prayer, Your Lordship. Because the petitioner has invested almost 50 lakh. All utensils, all the trees has been imported from Kolkata, and the season has come, Your Lordship, tourist season.
Mr. Mahanta, you see, we are with you, but provided you are,
Some relief, Your Lordship.
your action has to be within the four corners of law. There is an allegation of fraud.
Lordship, I say that nothing as such. The Lordship is going to the agreement. This is an agreement with Birina saying that I'm not the proprietor. A specific agreement, Lordship submitted.
That we are not concerned. That we are with you.
Yes, Your Lordship.
Birina is the first party. You are the second party.
Yes, Your-
But their later allegation is of much more serious
Just
consequence.
for a moment, then I may be allowed to show this clarification, Your Lordship, submitted by the T estate. The T
Where?
estate itself.
Well,
That Your Lordship will find at page 144.
144.
Yes. When I have submitted my representation of seeking a review, I have submitted this certificate issued by the Chaudhary Tea and Agro Industries, under which the Birina Tea Estate is, this Birina Resort is located. This is under Fatemabad Tea Estate. Birina Resort is not an independent body. It is under the Tea Estate. And that is how this has been issued. And they certify, yes, that during 3 years, the period from 15/1/16 was, I have run it. Nothing as such has been given by the general manager, Your Lordship.
Hartsbury K.K. Mahanta.
K. Mount.
K. Mahanta, learned counsel for the petitioner.
Some protection may be given you.
It is the case of the petitioner that pursuant to a tender process, a tender process initiated wide notice dated 3/8/2023.
22.
You have written 23. Why these mistakes? We're wondering how it is 23. List of dates.
Sorry.
22. 3/8/2022, comma, the petitioner had submitted its bid, full stop. The work was for running and developing a newly constructed cluster situated at Manas National Park, namely Panbari Basbari cluster.
Yes, sir.
Full stop. Pursuant to the said tender process, comma, the petitioner had also submitted an agreement with the Birina Resort, as per which the petitioner was inducted as a lessee.
Marina Tourist Lodge.
Tourist which was inducted as a lessee. Full stop. However, comma, accordingly, comma, the petitioner was given the work which he has been running.
180.
Full stop. However, in July 2023, a show cause notice was issued to him, wherein, apart from the allegation that the petitioner had projected himself to be the owner, public proprietor of the Birina Tourist Lodge, comma, a further clarification was given that on confirmation from the actual owner, comma, such agreement was denied. Full stop. The petitioner's denial and his prayer and his request to grant some more time was refused, and the contract was cancelled on 8/8/2023. Full stop. The petitioner had, however, submitted further representation to reconsider the decision, which has also been rejected by the order dated 1/11/2023. Full stop. Para. It is submitted by Sri Mahanta that at no occasion, comma, the petitioner had represented himself to be the owner, public proprietor of the Birina Tourist Resort Lodge, and the agreement in question clearly shows that the petitioner was a lessee. Full stop. With regard to the allegation that the actual owners of Birina Tourist Lodge had denied its connection with the petitioner, comma, the learned counsel has referred to a certificate dated page
7/9.
7/9/2023. Page 144.
144,
Yes, sir.
dated
7/9/2023.
2023, issued by the senior executive of Fatemabad Tea Estate, which is a unit of Chaudhary Tea and Agro Industries Private Limited, that the petitioner was given the opportunity to run the Birina Lodge for a period of 3 years, from 15/1/2016. But it was for 3 years.
Only for the
Yes, that is the eligibility criteria we need to submit.
But thereafter, after 19,
An experience of 3 years needs to be submitted. That is the only thing. And they dispute saying that we have not run. I was not the proprietor.
for a period of 3 years, from 15/1/2016, full stop. Para. Let notice be issued returnable on 12th of January 2024. For all the respondents?
Yes.
Sri M. Chettiar, London State Council accepts notice on behalf of all the respondents that extra copies of the writ petition be served upon him by tomorrow. Para. Sri Mahanta, the Learned Council prays for an interim order. Full stop. It is submitted that a fresh notice inviting tender has been floated
130.
on 24/8/2023. A long time,
Yes, then they have subsequently extended.
which
Next-
has been extended on 7/9/2023. But 7/9, we are at 12.
Yes, your lord. Some protection, lord.
What protection? Somebody might have been given.
No, no, till now, I think no third party.
And
right?
so it is further submitted that no third party rights have accrued, that is further submitted that till now the tender process has not been finalized. Full stop. Para. After hearing and to balance the equities, it is provided that if the tender process has not been finalized till now, comma, the status quo, the same shall not be finalized, and final orders of allotment cannot be issued till the returnable date. Full stop. Para. The aforesaid observation oblique order would, however, be reconsidered on the returnable date.
Deeply obliged.
Okay, welcome.
For vacating the stay order passed by this honorable court, by which my lord the tender process with respect to housekeeping services at Central Institute of Technology, Kokrajhar, was directed not to be finalized. We believe, my lord, we are the successful bidder, although no work order has been issued in our favor. My lord, the reason for which the
Yes, you have filed your objection. You'd like to file objection.
I'd like to file.
Let him file the objection.
file
First
it.
time it's been come up. Heard Sri S.J. Learned Counsel for the applicant, who by means of this application has prayed for vacation, public modification of the, it was an ex parte with
yes,
ex
on the-
parte,
yes, my lord, we had not been served notice.
with the ex parte interim order dated 18/9/2023, passed in the connected WPC 5427 of 2023. Full stop. Para. Sri A. Boro, Learned Counsel for the opposite party writ petitioner, however, prays for and is granted 2 weeks time to file objection. Full stop. Para. List on.
After view, before the
Okay. List on 12th of January. Full stop. Interim order passed early to continue till the next date of listing. You like to file anything? Okay, next. MS Egan, Learned CDC is present.
15 and 16.
But I was being asked to file an affidavit. I put the order 2411 lot.
Yes.
Those are cases that actually, my lord, NIT was plotted on 14/3/22. It is the NIT of 1 of 22, my lord. For settlement of several bill, including my lord, Fulbari, Anua, Fishery, my in Kashmir district. So against that, my lord, we have responded, my. So accordingly, tactical bid was opened, and my lord, a notice was also
Now,
issued.
why is it listed today?
Well, it is listed because lot interim is operating lot against us lot. To my
You have filed your affidavit.
yes, lot regarding the query made by the honorable court lot on 2411 lot.
2411.
Lot. The fact of the case is
In which writ petition? There are 2 writ petitions.
in 4053 they filed. Common order.
2411.
Lot.
2411. 2023.
Yes, sir.
Okay, 24 okay. That
Para, my lord, 5. Para 5 है in para का.
What have you stated in your affidavit?
Lordship, the fact is that, Lordship, we have in the tender notice one, Lordship, there are 3 bills we found that there are 2 tenderers. So as a politician, we went for retender in where there is 2 bidders. Lordship, in the last day, Lordship, the court, honorable court, inquired that whether we have gone for other 2 to the retender or not. That part we have responded to, Lordship, that we have gone for other person and another bill was also there. We have also gone for retender where there are 2 bidders. Here there is my learned friend's case is that as because there are two bidders, we have gone for retender. Is illegal. I think their part. So they are not. So it was state lordship. It was not listed for many.
The stay is only pertaining to this particular bill,
Only part.
not the other 2.
Not the other 2. Other 2 have settled. They have not come forward. They have not come to this.
There was no challenge with
No
regard to
challenge.
cancellation.
Yes, sir.
Only this has been the challenge. Yes, Mr. Ghosh.
Now, my lord, lordship will see kindly.
Why didn't you participate in the new tender process?
My lord,
If they have a new tender process, what is the embargo you are having in participating?
my lord, in that case, my lord, first tendered, my lord, in 1 of 2022, my lord, we have participated.
That understood, but
Yeah.
if they want to cancel it.
No, my lord,
round, then
because there is an interim order pertaining to that. They have plotted subsequent tender of 4 of 2022. Against that, we opposed before the lordship. My lord, there is an interim order not to finalize the tender. But their affidavit said that tender they have also finalized, despite of the interim order operating the field.
Have you?
Yes,
said-
no, lordship. Lordship, my kindly see. Secondly, they said they have decided to retender it. But if your lordship now look into page, my lord, 28 of the WPC 4053, they have taken a decision according to their affidavit on 12th, on 12th, decision.
Lordship, may I say, Lordship? No. With little correction, the first tender notice was 1 and 1. Here, Lordship, they have, while participating in a technical bid, we have decided to go for retender. So we have issued another tender, Lord. So we have not opened the financial bid, Lordship. Technical bid was, as because we have, in the minors also, Lordship.
Now, if you are agreed for a final disposal, you can have it for final disposal.
On my lord, on 12th, lordship will see on
Mr. Ghosh,
lordship.
let us
Yes.
finally hear the matter.
Today, my lord.
Yes,
On my lord, on lordship, yes, on 12th.
one matter. is
Dr.
there.
Tani. Huh?
Huh?
Kumar,
Maybe one number. কাম কৰিব পৰা এই বহুত আছে তো এইটো লাষ্টত মাতি দিম we'll have it after the expiry of the list today itself if you are agreeable, otherwise we can have
Yes,
it
I
after
think it, Lord.
as last item let me hear because
my lord,
final hearings this week we are not having. This we can have it as an exceptional matter, but after the matters, other matters are over.
lordship may then take up a view because second half I may not be there because I appointment.
Lordship, here, Lordship, for 1.5 years.
Your appointment is in court number 10 at second half. Fixed already. No cancellation. No, if you have a real difficulty, then
Difficult, my lord, 22nd I'll be operated on the. So I on me. That's the problem. Otherwise, my lord, it's not.
now we do not want to have many councils are waiting. Senior councils are there
Yes, yes.
on the last date.
Very
Let me
good.
have it after the week. Second half is not there. Otherwise, you would have taken.
Otherwise, I have no problem, my lord. Only because of that.
Lordship, the matter is everything. Though disposal in the matter, Lordship, the matter is not that real issue. My learned friend was also agreeable, Lordship. Here, technical bit will if Lordship, heart matter, it may complete within 10 minutes also, Lord.
Your 10 minutes may not be the court's 10 minutes.
Lord.
We may not be that fast as you are.
No, Lord, I'm not.
Okay, we'll have a date, Mr. Jukos.
Hello.
Of your convenience, when will you be okay? Tell us.
After
On 9th Tuesday?
yes, Lord, we have a problem, Lord. For the 1.5 years, no, we are interim, Lord. It is maybe both parties are fault, Lord.
You tell us. We are agreeable to have it the second half.
So
He
not
has a-
it. Let's do it. Let's try it.
No,
I
he's
will not
having a
have-
second,
I'm-
he's having a personal
Otherwise, why all of
difficulty.
this thing? I understood. Yep. Day after tomorrow operation. We can improve. Okay, it's okay. On 4th, Lord.
4th. On 4th. 4th, Mr. Ghosh. 4th.
My Lord. I love it.
The necessary pleadings have been exchanged and and it is submitted by the learned counsel that the matter can be taken up for disposal at the admission stage.
Yes, yes.
Mr. Para, list on 4/1/2024. Is there any interim order?
Yes, yes, yes.
Interim order to continue till the next day of listing? Yes.
I love.
17 and 18.
Yes.
Yeah, Lord, government is supposed to file affidavit, but no affidavit has been filed.
What is the matter?
Yeah, grievance of the petitioner is that the Deputy Commissioner Borpeta issued an NIT for settlement of a Blacklisting bill fishery. And we are not.
Yes, where is your affidavit?
Yes, my lord, we have not
Mr.
filed it. The report was also for my lord. We have not received the record. We have received instruction on that is not sufficient.
Mr.
to file
Kotak for
affidavit, my
whom?
lord.
R6.
As respondent
You
was,
file affidavit.
yes, sir.
Some time is required, my lord. We have received one instruction, my lord. That is not sufficient to file an affidavit.
Yeah, but this matter is pending since 2021.
Yes, Lordship. We are suffering, Lordship. The Lordship may dispose of the matter, directing the Deputy Commissioner to decide the issue.
Okay,
because-
we'll have it for final disposal. You get the whatever instruction is there, you can file, otherwise old matter. Sri M. Chitty, let the State Council prays for some more time to file the affidavit in opposition. Full stop, para. Sri S. Deka, Learned Counsel for the petition, however, submits that delay in disposal is causing prejudice. Para. Sri S. Kotoki, Learned Counsel, is present for respondent 6, who
Next.
respondent 6 in WPC 2056 of 2023, who is also the petitioner in the connected WPC 2172 of 2021, and has filed his affidavit. Mr. Para, as agreed to by the parties, list for consideration on 8th of January.
Apply.
Item 19 and 20.
Lordship, I have filed my affidavit in this matter. This matter become influx to us. We are not going to close any new NIT, and the procurement was up to March 2023.
Oh, my lord, there is the interim order. And my lord, there they have shown the reason of
No,
cancellation.
they are not going ahead with the new procurement.
My lord,
They are not taking any steps for new procurement. Then it has become infructuous, I think.
my lord, the interim order may kindly continue. I am filing a reply.
Continue
Because-
for what? We are
Yes, because I am
taking
filing a
decision
reply.
in the tender
Yes.
notice. We have
Oh,
cancelled the
just-
tender.
I have challenged the cancellation order. Order of cancellation is challenged before this court. And interim order is here, my lord. Yes,
The interim will take a decision with the tender.
that decision I have
continuity.
challenged.
We have taken the decision. We have cancelled the earlier tender process as per the view of the finance department.
My lord, I have challenged that order. It is in the
Are you going ahead with the fresh tender process?
We are not going to close any fresh tender. We have written in our affidavit, page 6.
They are not going ahead with the fresh tender process.
Because Lordship may kindly record that paragraph,
But
paragraph 13 of my affidavit.
Lordship,
page
I will make a
61, my lord.
submission. Let her make the submission first.
No, this is
Don't you
infrastructure
have to-
matter, that's why I am saving
No, no.
honorable court time, my
I will
lord.
reply to her.
Well,
61 says, paragraph 13.
But madam, he is put to challenge the cancellation order.
But there
Yes.
is no interim order in the cancellation order.
There is the
Because
interim order.
Lordship may,
No, but that question which he is raising, that has to be adjudicated.
Lordship may kindly take up the matter for final disposal, but we are not going to float in tender because in paragraph 13, Lord, we have mentioned.
That is okay. New process you are not going, but his cancellation of the earlier tender process, that is the subject matter of challenge.
But Lordship, may I read in paragraph 13 matter?
Of?
My affidavit, page 61.
Yes, please.
Page 61, paragraph 30, my lord.
Please read.
Lord, that to regard the statement made in paragraph number 20 for petition, the deponent begs to state that as the tender was in regards to a state-owned priority development scheme for the year 2022-2023, and the budget provision for the procurement was up to March 2023. So, Lordship, it is up to my lordship. The lordship executive matter, lordship fix the matter immediately vacation.
Lordship kindly see page 67 of their affidavit. Page 67, what they are doing. Paragraph, my lord, paragraph 2 of their page 67, my lord.
Yes, please.
Paragraph 2.
Yes.
Under the second bit tender process followed here, if any tender either should have been rejected owing to not fulfilling the requisite quality criteria, it should have been done at the technical evaluation stage itself. After opening the financial bid, in the financial evaluation stage, the lowest evaluation bidder should only be awarded the contract. They are going to show the favor to the lowest tenderer, which was rejected earlier. Okay, please let me make submission.
Okay, we'll have for final disposal.
I will reply to the affidavit.
Okay. Reply to whose affidavit?
Their affidavit.
Okay. File a rejoinder. Okay. The respondent number 4. Who is the respondent number 4, madam?
Lordship, the director, sorry,
Directorate,
Sure Areas Development Assam.
Directorate of Solar Areas Development, Assam. Why 3 is the different and 4?
Lordship, he has sorted the tender.
3 and 4.
They have met, the petitioner have met the same respondent twice.
Mr. Saikya.
Hello. Typing mistake. It is respondent number 3 and 5. Typing mistake. Repeat it.
The director of Solar Areas Development has filed an affidavit in opposition, who is represented by MSMD Bora. Full stop. Para Sri Saikya, RC Saikya, learned counsel for the petitioner, submits that he would file rejoinder affidavit. Full stop. Para. Let such affidavit in opposition be filed. Affidavit reply be filed, and the matter be listed for consideration on when?
After the due vacation.
On 19th of
Lordship, after 20, my lord.
on 22nd. 22nd of January 2024. Para
Lordship,
interim order passed in
23rd. 23rd.
23rd will be 24th. 24th.
And the interim order will continue.
Yes.
Lordship, may I point out one thing? Interim order was stated not to take press.
Anyway, interim
How
order
did
interim order will continue. Interim order continue.
Yes,
There could be further definition of interim order.
continue?
Yes.
Lordship, senior counsel Ken sir is on leave. Pastorwati madam, may I request
As per the order of the Honorable Court, hearing was conducted
time may be taken after some time.
Yes, then what happened?
and inspection was done
Yes,
yesterday. Madam. So my that matter is pending for
Have-
the taking the final decision. The process of final
He has appeared.
appeared.
Okay. The MS as Chutia, learned counsel representing the GFC, has submitted that pursuant to the last order dated 4/12/2023, the petitioner had appeared and a hearing had taken place. Full stop. See
Inspection was-
accordingly placed for some time to place on record the decision of such hearing. Full stop. Para list on when? List on 5th of January 2021.
My lord, by order to 16/3/2023, my lord.
Yes,
petition of my lord.
affidavits filed.
But the extra copy not of my lord, it take.
My lord, coordinate bench of this honorable court, my lord.
Why you have not?
Similar order.
You have to.
I am praying for similar order.
They are yet to respond. You are playing for similar order. You have not even served extra copies. Similar order cannot be on the same. It has to be identical facts and circumstances.
Identical.
Is it identical?
Yes, yes.
We'll have to examine.
Same order, my lord. Impugn order, same, my lord. All the petitions are different.
Yes. Give extra copies. We'll have immediately on the vacation.
Yes, ma'am.
Yes, in the meantime, they may be asked to produce the consent to operate that they have obtained from us. Because without that, they cannot operate. And inspection report makes it very clear that the
Okay.
industry has been
It
functioning.
appears that extra copies of the petition has not been served. It appears now. It has been submitted by Sri M. Chetia, London State Council. That extra copies of the petition has not been served upon him. Full stop para. Sri Chauhan, the London Council, for the petitioner on the other hand submits that similar matters has been disposed of. Matters have been disposed of, and he prays for disposal of this writ petition in terms of those orders. Full stop para. Be it as it may, comma. Let an extra copy of the writ petition be served upon Sri Chetia. You have been served. Others have been served.
Don't have it.
Have you? Otherwise, you have the instructions.
I have.
Be on Chetia, United State Council, and the matter may be fixed on 10th of January.
Okay.
The Chaudhary for whom? Also had Sri B. S. Barua, London Standing Council PCB, Sri B. Chaudhary, Standing Council Agriculture. Mr. Kolita for Industries Department. M. Kolita for Industry Commerce Department. RDB for CCC. CCC are present. Okay.
Right.
23 to 25.
Make Procedural. So these three petitions are identical in nature, my lord. This is regarding supply of fertilizers, micronutrients and pesticides in the, my lord, agriculture department.
Yes, affidavits filed, exchange.
Affidavit has been filed. And my learned friend was there in a, my lord, they are expressing urgency. Your worship, my lord, takes up for final.
You tell us if you want, we can take it up today after the matters are over.
I've got the because the interim is a conditional one, and everything is the last stage of technical effect. I'm ready, my.
After the matters are over?
Right.
It will be set, huh?
You're 47, please.
Sharma,
Yes, my
PNRD?
yes.
Yes.
So this matter relates to settlement of illegally marketed for 1 year. The term will be over in the month of June 2024. And my lord, initially I was selected and notice of acceptance was issued, page 31. But there was a condition that I should submit the requisite amount.
Submit the?
Amount
Okay.
each month within a period of 3 days as
Oh.
per notice 57. I received the notice on 10 June.
Which
Then-
notice?
yeah, notice of acceptance, settlement for notice of acceptance.
What date? Otherwise, what is the date?
That my lord, 6/7/2023.
6/7/23 is what?
Notice of acceptance, it is issued by the authority to me, but at the time I was out of session and I got the notice on 10th of July,
10th of July, after 4 days.
4 days. Then I went to the office of the executive officer, Borpeta Sita District Committee.
Okay.
Then I requested the authority to collect my fees. Then they refused. But one day prior to that, they have settled the market in respect of the respondent number 4,
Who is person number 4?
respondent number 5,
Private.
private respondent. Then,
At what rate?
my lord,
What was your rate?
my rate was 9,21,102, and private respondent number 5, 8,11,905. Only on that ground,
What R?
R5.
R5, okay.
Yes. Only on that ground, my case was rejected. But I came to know that the private respondent he was given notice of acceptance on 14/7/2023, and final settlement order was issued on 19/7/2023. But he submitted the land document. He procured a land document from the circle office after 10 days from the date of settlement. So if the notice of acceptance was cancelled on that round of 2 or 3 days delay, same principle should be applied to the private respondent. And therefore, this honorable court on 9/10/2023 directed the authorities to clarify this position. But the respondent notice to the
There's an interim order.
no much. The private respondent is enjoying the benefit, my lord. At that time I was the current listing. So they should wait for 2 or 3 days. But in spite of that, my lord, private respondents were given the settlement.
Yes, what do you say?
That position has not been clarified. Yes. Paragraph page 50, just have a look, my lord.
50.
Yes, my lord.
Filed by a private respondent.
Yes.
If
Affidavit in opposition filed by the respondent number 5.
So number 5. It's 42. It's 42.
Then 50, page 50.
It's 42.
Page 42 on what? Then page 50 is the annexer land document.
50.
Yes. That land document was procured by the private respondent from the circle officer. That is the put the signature on 24/7/2023. Then notice of settlement was issued on 14/7/2023. And final settlement was issued on 19/7/2023 without having the land document.
Okay.
If my case was rejected.
Okay, understood.
And therefore, on 9/10/2023, that question was directed to be clarified. 9/10/2023.
Okay.
That was not.
My lord, this case has two different statements. First case, my lord, the case of the petitioner. That's the second case, the private respondent.
There are two petitions.
One writ petition, but with the department, we are first challenging the locus of the petitioner because he himself is my lord defaulted to come within time. Because my lord, the record is here, my lord.
That he has admitted that there was a delay of 1 day.
Yes, my lord. Delay of not 1 day actually. As per clause 10, 3 days, my lord. And he suppressed one fact, my lord. We have
7 days.
Lord, you may kindly come to my affidavit, my lord.
Page?
Page 63, my lord.
63, yes.
This is the notice issued to him, my lord.
Page?
Page 63. Correct.
Yeah, Mr. Sharma, your name is Naimuddin.
Yes.
Okay.
And below, my lord, there is a signature, my lord. Aklima Khatun. This is the wife of the petitioner number 1, my lord. See, as admittedly he was out of petition, my lord. The wife of the petitioner came and received, my lord. They were the earlier lessee, my lord. But after receipt on same day, 6/7/23, they never came up, my lord. Therefore, they don't have any locus to file this challenge this case. That is part 1. And the second part, my lord.
If they had come up to deposit, there would not have been a case.
Yes, my lord. As the fixed date, they didn't.
What is
yes,
the dispute?
Yes.
That he was not in town, your signature is of the wife, which rather 45 is his position that he was personally not there.
Yes.
But leaving aside all, even if you hold that it was, but there is a delay of how many days?
According to the notice, I should come to on 13.
Within 3 days, you
5
came
days.
when?
7 days. As per NIT, 7 days. As per clause 20, 7 days.
For clause 10, 3 days. For deposition of money, 7 days.
Okay. And he came
Clause
after.
10, 3 days.
Clause 10 is what for what?
For document, deposit document.
And money?
Money for 7 days. But he didn't come up, my lord. Within time.
Clause
Clause
for
10 for 3 days
I have
for
submitted
documents.
for document.
And for money?
For money, 7 days.
Clause
20.
20.
for kist.
Yes.
Okay.
If
7 days.
if he will submit document, then only 7 days will come.
My lord, I have submitted the land document on 7/7/2020.
No, the cancellation is for non, or rather your impute action is for non-submission of the kist or document.
Both.
Both.
Yes, ma'am. Thereafter, my lord, on 6,
No, you tell her we have to be very clear with the dates.
yes, ma'am.
14/7/23, you had served him notice.
My lord,
Okay.
my lord. Notice, my lord.
No, sorry. 6/7.
Yes, ma'am.
Okay.
And petitioner's wife accepted on the same day.
Okay. He had 7 days.
Yes, ma'am.
3 days for documents and
7 days.
7 days for money. When did he deposit?
My lord, as per records, he didn't come, my lord. After the settlement order, next day he came up.
When was the settlement done? 19/7.
14/7.
14/7 was the order, my lord. Because some documents also required, my lord, for the private respondent. So 14/7, after the General Standing Committee's resolution, my lord, we have issued notice to the private respondent on 14/7 to deposit the documents as well as the.
Mr. Sharma, when did you go to tender the amount and the documents?
15, my lord.
Huh?
I admit, my lord. 15.
Page.
Page 32 of my petition.
15/7.
Yes, 15/7. And I have submitted the document on 7/7. In paragraph 7, I have stated, my lord, my guarantor has submitted the document on 7/7/2023.
7/7 itself.
Yes, my lord. They have acknowledged the document. Then document.
This is the 14/7 document. Before the 15/7, my lord, 1 day prior, we have already issued offer to the private respondent.
Notice of acceptance.
But he has procured the land document after 10 days.
Record is not saying so, my lord.
The private respondent has admitted, my lord.
I don't know what document he annexed, my lord, but as per record, there is a different document. And this is the resolution, my lord, of the General Standing
The General Standing Committee has provisionally accepted your tender for settlement. So you have a request. Necessary record they were.
Page 33. Requested.
But has the private respondent fulfilled this
Yes, my lord.
condition? When did
After
he
fulfilling
deposit?
the first page is there, my lord, of that bunch of papers, my lord, first page, after fulfilling the conditions, my lord, that was issued, my lord.
Date 19/7.
Yes, 19th. And I don't know private respondent what document he annexed, but as per our record, my lord, he submitted on 18th, 17th.
Where is the record?
Yes, this is the record.
What was submitted?
This document was submitted, my lord.
What document?
Same document, but without it, but I don't know how he annexed.
Then in this particular page, which Mr. Sharma is trying to rely,
Page 50, my lord.
what is that document?
That document is not same document.
He already has that land document, my lord.
Yes.
There are 5 of that. That the document.
Circle Officer, Bagbor Revenue Circle.
24/7/2000.
And this page 50 is whose document?
Private respondent has submitted.
No.
His own document.
No, that we have understood. Who has brought on record?
That document was submitted, my lord.
I think the difference between these two documents is that that document that is the computer generated.
Yes.
That document was submitted. Here
Annex
In my-
the
in
annex
my
the
affidavit-
separate document.
Safikul is whom?
Private
respondent number 5.
But this, you have, it's a part of your affidavit.
Yes.
It contains a signature of the Circle Officer, Bagbor Revenue Circle.
that is certified copy of that document. The annex. But in the original our record, this is the computer generated. It's not a case that he doesn't have that local landman.
On page 29, the comparative statement, both of us, my lord. All the documents, the remark column are nil. Land document nil.
What
Other-
is your name? Time or date?
Yes.
Petitioner.
Yes, no, page 29. The
And your name? Where are you?
serial number 3.
Original is there, but with the
Safikul Islam.
2 and 3, my lord.
Okay, 2 is petitioner.
Yes, sir.
And 3,
Private.
who is Ataur Rahman?
Ataur Rahman, he has withdrawn from the center.
Bidder number 1, he withdrawn.
And Safikul is how, R5.
Yes.
Yes.
The remark column, Mati Thokar Pramanpatra no, then other document also nil. As per comparative statement, page 29 and 30, in respect of the private estate. With financial certificate needs, affidavit needs, then non-incumbency certificate also needs.
So he's only Mati Thokar Pramanpatra is nai.
Yes, sir.
What else there?
There's no,
Loda in so he's also there. Apex code observed, my lord. It's up to the authority, my lord.
Video,
one of the
nai,
main
nai.
conditions. That BTS Askalata Pramanpatra. Affidavit needs, then other.
Interesting. Now, if, Mr. Dutta, if the private respondent, most of the documents were not there, why was his bid held to be valid?
Have not clarified, let me type it.
My lord, we
If
have
you, see the
given time.
if you see the comparative statement, Mati Thokar Pramanpatra nai, and
BTS.
what is this first one? Nai, again, Bityo, Socialita Pramanpatra nai. Even prior this thing, what is this? Solita Bosara Mati Khazna Adai Rusi nai.
Lordship is holding the original one.
Yes. The comparative statement.
Original comparative statement. With the bunch of papers.
Yes. These are the tender papers. Where is the
There are some other papers.
this one?
Yes. No, that is the general standing. There is another one.
Okay, this one.
Yes.
Okay, yes. Correct. Topical. I. 3.
The note is also there, well, standing committee.
মাটি থকাৰ প্ৰমাণপত্ৰ নাই। দেন চলিত বছৰৰ মাটিৰ খাজনা আদায় ৰচিদ নাই। বিত্তীয় সচ্ছলতাৰ প্ৰমাণপত্ৰ নাই। শপতনামা নাই।
They've deposited my.
When?
My lord. The documents.
Then why do you need a comparative statement? Everything you can give later on.
Yes.
Why him? Okay, he's cancel. You cancel his bid. But why do you select a person who has got no documents?
As per clause 10, my lord.
The first bidder, Anwar Rahman, submitted withdraw.
In fact, petitioner was also, my lord, offered, my lord, to submit documents. He has not submitted the bid.
Petitioner.
When petitioner came up, my turn up, we have settled with the private respondent so that at least revenue can be generated.
No, so far as petitioner, you are Naimuddin.
Yes,
Naimuddin is concerned, there is no default.
Default is there, Mel.
There is no default in your comparative statement.
All are asked.
Everything is yes.
Why I have been ousted, but there is a don't mind. But there are some illegal.
Okay, we'll come back at 2 o'clock. What is the present now stage?
He's running, private respondent is running.
For settlement for how many years?
Well,
In the month of
it
June.
will up 30th June, up to 30th.
Let us see.
I was running the market, my lord, for that.
Oh, কি থাকিল আকৌ? আছে নেকি? Huh? Bail. Bail CD আহিছে. Any, yes. CDs, only one CD. Rest, not. Interim orders are there.
But
in few of them.
moreover, my lord, in 2 cases, 27 and 8, 30 has been submitted.
Okay, are the lawyers there available? 27. Unnecessary will not detain them. 27. 27 what? You have the same case diary?
Lord, in 27, charge sheet submitted, Lord.
Okay. What is your name?
MS Hussain.
You are in 27.
Yes.
Muhammad Afzal Hussain Talukdar.
Yes.
Your name is not there.
On behalf of AM Borough.
M.S. Hussain.
MS.
First three MS Hussain letter consent for the petitioner. Also heard who petitioner who has filed his application under section 439 of the CRPC or 438 of the CRPC in connection with service. This court also heard Sri Soenso, learned APP who submits that charge sheet has been submitted. Full stop para. This court has also noticed that there is an interim order operating in this case. Full stop para. In view of the efforts and development, this petition is closed by directing the petitioner to face the trial and pray for regular bill. Full stop. It is however observed that till such prayer is made, which has to be done on the prayer is made, comma, the interim order shall continue to operate. When is the date fixed
For next
in the trial?
trial,
Till the date fixed will be probably, huh? It is however observed that till made on the date of appearance, on the date of appearance. Yes.
28 also.
28, who's there?
Your Lordship, I'm appearing on behalf of Mr. K. Bora.
Interim order is there? Yes, same order. Huh? What is your name?
Miss P. Bora,
P. Bora?
appearing on behalf of Mr. K.
K.
Bora.
Borua. Huh? Okay. Okay, order. Okay. Good, good. This is 27 and 28. Yes, yes, okay. And cases where case diaries are not available?
Not available, Lord. Only 33 is available.
Are the learned counsel here in the court?
30 for 32 are there. LCR was called for, but that was not received, madam.
Okay. LCR?
LCR, madam.
Okay, 32. We have another date. It'll come for which place?
It is from Karimganj, madam.
AB in an LCR. Why AB?
It's a charge-sheeted matter. Someone is, that is why I have malrepresentation. So I have filed this AB, madam, and anticipatory bail application, madam.
32. It appears that the case records have not, a scanned copy of the case records have not been received. Full stop. Registry to issue reminder and release this case on 12th of January.
12th of January.
Item number 30. 12 January. Yes.
In 31 and 34, my lord, interim is there, but we don't have the
31, 34.
34 I'm appearing.
31. Okay. 31 and 34. Case diary, it is submitted by Swiss London APP. That case diary is yet to be received. Full stop. Para list on 18th of January 2024 for receipt of case diary. Para interim order to continue till the next date of listing. 31 and
34.
Okay. Okay. Any more? Case diary is not there. TDW 35.
35 year old.
Case diary is there or not?
Not okay.
Okay. No interim.
No interim. Your lord.
AB. Okay, we'll have it early date. So it is so London APP submits that case diary has not been received. Para list on 8th of January for case diary. Okay. Baki over. Rest will pass at 2 o'clock. Or was it goodbye? Anyone in the bail matters? Huh? Item? 2930. M.I. Chaudhary, anybody there?
Yes, Lordship.
Case diary?
Case diary is not available. They have completed, Lordship. The informant is also there. Please inform me, but the case diary is not received.
There is interim.
No. It is a POCSO 3760.
Okay.
POCSO is also there.
Okay. Item number 2930.
Lordship, the respondent number 2 has filed an affidavit. We have got a copy, but perhaps not the record.
We'll have that will not make much difference. In both the matters, private respondents have appeared. 2930.
The 30 is different, Lordship. 29. I'm talking about only 29.
29. The informant has entered appearance and has also filed an affidavit, which however is not with the records. Full stop. Para. It is also submitted that the case diary is yet to be received. Full stop. Para. List on 10th of January along with the for receipt of case diary. The affidavit filed by the respondent number 2 may be tagged with the records. Okay. 30. Anyone there? SSS Rahman? Rest at 2 o'clock. NIT was what date?
T5/2020. Page 18.
3
T5/2020.
NIT for?
Settlement of Milijili market. There are so many markets.
Milijuli is where?
Chhatrapana Gaon Panchat under Mondia Anchalik Panchat, Mondia, Barkata.
If you were out of station, how could you deposit the submitted documents on 7/7?
On a land document on my behalf, the current normal, my PDP reply, paragraph 7.
Okay. Okay. Yes.
Submitted my. As per record. That document, my lord. Not with seal, my. But not, that is not official.
Which document?
One document my colleague has.
Right, but right next.
Settlement period is from?
Up to 30th.
Yes, what should be done? Tell us.
A settlement order may be set aside by directing the authority to cite the matter and the eligible that settle the. There is a clear discrimination.
Mr. Khan? His wife has received.
Wife. There are but not Tata. There are not so sent to the according to the number 5 applied the
But your bid was defective.
As per comparative step.
was the about the but I was that
There were no other bids.
I
The-
Next,
No. Your bid was defective. Many of the documents were not given by you.
by so but can but I was
close that.
And your price is also less by more than 11,000. His offer was 9,21,000.
not a fair deal.
not applied. Because 67
But he has made a statement that on 15/7 he had come to the office to deposit.
it's also after
Already 14 decided, my lord. Offer was made.
But 14 did he deposit? He deposited when? 19/7.
24/7.
What happened on 19/7?
Final settlement.
Final settlement, that was final settlement.
And
After
land document at 24/7 will not go by that, will go by his document.
Right.
But from 14 to 19,
Document cannot find. It can be a lot that was submitted, that was submitted.
that date we are not accepting Mr. Sharma's thing. We will not go by 24/7. Let us go by 19/7. From 14/7 to 19/7.
Yes.
How do you explain that?
19/7 is the settlement order, my lord. He's on 17th he deposited.
Where have you stated? What is that clause? Let us see.
Yes.
Clause,
Clause 10.
page,
Page 24 is vernacular language.
Page 24, my lord.
clause,
Clause 10. May I read, my lord?
yes.
সকলো বজাৰ ঘাট মীনমহল পাউণ্ডৰ ক্ষেত্ৰত সৰ্বোচ্চ নিবিদাকাৰীৰ নিবিদা বিবেচনাৰ বাবে গ্ৰহণ কৰা হ'ব। যদি কোনো সৰ্বোচ্চ নিবিদাকাৰীয়ে নিবিদাৰ লগত প্ৰয়োজনীয় নথি পত্ৰ কোৰ্ট ফি আৰু অমানতৰ ধন বাদ দি কোৰ্ট ফি দাখিল কৰা নাছিল, তেনে ক্ষেত্ৰত সেই নিবিদাকাৰীক সেই নথি পত্ৰসমূহ জমা দিবলৈ সৰ্বোচ্চ 3 দিনৰ সময় দিয়া হ'ব। যদি সেই নিবিদাকাৰীয়ে নথি পত্ৰসমূহ নিৰ্ধাৰিত সৰ্বোচ্চ 3 দিনৰ ভিতৰত দাখিল কৰিব নোৱাৰে, তেনে ক্ষেত্ৰত তেওঁৰ নিবিদা নাকচ কৰা হ'ব, লগতে আমানতৰ ধন বাজেয়াপ্ত কৰা হ'ব আৰু পৰৱৰ্তী উচ্চ নিবিদাকাৰী উপৰোক্ত চৰ্ত সাপেক্ষে বন্দোবস্তিৰ সুবিধা প্ৰদান কৰা হ'ব। Next, therefore, as per clause 10, we have offered private respondent for settlement.
No, but the offer has to go to whom? The
Next
highest
highest
bidder,
bidder.
highest bidder, first to the highest bidder. First, it has to be go to the highest bidder.
One withdrawn, then second we have offered as per clause 10. Second we have offered.
Please
Then,
read again. Please read again.
my lord. সকলো বজাৰ
সকলো
ঘাট
বজাৰ ঘাট মীনমহল পাউণ্ডৰ
পাউণ্ডৰ
ক্ষেত্ৰত
ক্ষেত্ৰত
সৰ্বোচ্চ নিবিদাকাৰী নিবিদা বিবেচনাৰ কাৰণে গ্ৰহণ কৰা হ'ব। It is the highest bidder.
Yes.
Okay.
Yes.
যদি কোনো
সৰ্বোচ্চ
সৰ্বোচ্চ
নিবিদাকাৰীয়ে
নিবিদাকাৰীয়ে
নিবিদাৰ লগত প্ৰয়োজনীয় নথি পত্ৰ কোৰ্ট ফি আৰু অমানতৰ ধন বাদ দি দাখিল কৰা নাছিল, তেনে ক্ষেত্ৰত সেই নিবিদাকাৰীক সেই নথি পত্ৰসমূহ জমা দিবলৈ সৰ্বোচ্চ 3 দিনৰ সময় দিয়া হ'ব।
what is the judgment of the larger bench here in this section
Not
10?
yet. And that is regulating only on.
Now, this is
one-
what? Please read the second line again. যদি কোনো সৰ্বোচ্চ নিবিদাকাৰীয়ে নিবিদাৰ লগত প্ৰয়োজনীয় নথিপত্ৰ, it is
Yes.
only for the amount, for the documents.
For the documents, yes.
What have you stated about the money?
Except court fee and,
What have you stated about the kist?
my lord,
This is only with connection with documents.
documents, yes. 20 is the case.
Clause 20.
20.
Yes, 20.
Yes.
On
Please read.
page 25. বন্দোবস্তি পোৱা নিবিদাকাৰীয়ে after the offered, my lord, বন্দোবস্তি মূল্যৰ 30% আৰু জামিন চিকিউৰিটি হিচাপে বন্দোবস্তি জাননী প্ৰেৰণৰ এসপ্তাহৰ ভিতৰত জিলা পৰিষদ বা আঞ্চলিক পৰিষদত জমা দিব লাগিব within 7 days. বন্দোবস্তি বছৰৰ 1 জুলাই মাহৰ পৰা আৰম্ভ কৰি প্ৰতি মাহৰ 7 তাৰিখৰ ভিতৰত বন্দোবস্তিৰ মাহিলী ধন জমা দিব লাগিব। একেৰাহে 2 মাহ বন্দোবস্তিৰ ধন জমা দিব নোৱাৰিলে বন্দোবস্তি নাকচ কৰা হ'ব আৰু জামিন টকা বাকী থকা মাহবোৰৰ শেষ কিস্তিত চামিল কৰা হ'ব।
Clause 20 says one week.
1 week, 7 days to deposit the money after offer.
Let us see your offer to deposit after 1 week that you are not there. Page.
In my affidavit, my lord,
Is it 33?
my affidavit page 63.
33?
63, my affidavit.
No, page 32, I think.
Yes, page 32 and page 33, they have received acknowledged the data 15.7.
Please read the vernacular.
অভিনয় বিনীত নিবেদন এই যে মই সত্ৰকৰণা গাঁও পঞ্চায়তৰ অন্তৰ্গত মিলিজুলি মাৰ্গ বজাৰৰ 23-24 বৰ্ষৰ বাবে নিবিদা দাখিল কৰিছো। নিবিদা দাখিল কৰা সকলো নিবিদাতকৈ প্ৰথম স্থানত আছে। কিন্তু যোৱা 6-7 তাৰিখে বিট অফ ভেলু জমা দিয়াৰ বাবে জাননীত অসুখ থকাৰ বাবে মই ভাবিব পৰা নাছিলো। আজি মই মিলিজুলি বজাৰ নামত বিট অফ ভেলু জমা দিম। গতিকে মহোদয়ৰ ওচৰত প্ৰাৰ্থনা জনাইছো, দয়া কৰি উক্ত বিট ভেলু গ্ৰহণ কৰিব।
What is their response?
My lord, response was that, my lord, before that, earlier day, already we have offered the private response.
He was not informed on
Because
that day, my lord.
from 6 July, my lord, already he missed the bus, my lord. That is our set.
He was not informed even I submitted an RTI application on 18 regarding paragraph 7 regarding settlement of the market. I was also not informed. Then so it was backdated. Paragraph 7. On 18/7/2003, the petitioner submitted an application under RTI before the STI for Petazilla project seeking certain information regarding settlement of municipal market for the year 2000. Till 18/7/2023 was not aware.
Lord, you may kindly come to page number 58.
That's right.
This is our affidavit, my lord.
58.
58. It's the 10, my lord. Department. The last paragraph.
Yes.
That may read, my lord. But the writ petitioner, after receiving the acceptance notice on 6/7/23 through his wife, has willfully, negligently, voluntarily, and deliberately not complied with the acceptance notice until 15/7/2023. So we are admitting that 15/7 he submitted that application, on which he was submitted a petition on without assigning reasonable or valid ground within 3 days, nor within 7 days prior to 14/7/23. Before cancellation.
Where is the cancellation?
Cancellation is the resolution, my lord. There is a resolution on paper. I have given it the record, my lord. General Standing Committee's resolution, my lord.
Where? Which document?
There is photocopy of that resolution.
Which
The-
bunch?
with the
His
record.
bunch.
One photocopy. No, my lord. There is another.
Okay.
I have flag marked that page.
What is the name of the market? Millie's.
Milizuti. Top one.
But in the resolution, you have stated that within 3 days he had not come forward. The requirement of the tender clause 20 says he gets 1 week's time.
20 is 1 week. But it's not a case that in hand, my lord, that he came up within 7 days.
7 days will expire when? 1 week will expire when?
13.
On 13.
30.
13. He came on 15.
And on 14th, after 7th day, on the 8th day, my lord, on 14th, we have offered the private. And accordingly, he deposited the money.
Okay. Anything else?
Pass the appropriate order on the basis of the comparative statement. Since I was running the market, I was the current lessee at that time. I was running the market up to July. I have handed over the market on 21st of July. So they could have waited 1 or 2 days.
That's not
Even my lord, on the date of submission of the comparative statement, there is all or no in respect of the private. And on 18, when I submitted RTI reply on 18/7/2023, till that they have not settled the market. Because this is the RTI reply, they have acknowledged on 18/7, they have not informed me.
Heard. Sri N. Sharma, learned counsel for the petitioner. Also heard Sri S. Datta, learned standing counsel, Panchayat and Rural Development Department. Full stop.
1 to 4.
Sri, you are A.M. Khan?
Yeah.
A.M. Khan, learned counsel, has appeared for the respondent number 5. Full stop. The both the department as well as the respondent number 5 has filed affidavit in opposition, and the petitioner has also filed rejoinder. Full stop. Para. Considering the facts and circumstances, which includes the aspect of settlement of a market for a period of 1 year, and as agreed to by the parties, the instant writ petition is taken up for disposal at the admission stage. Full stop. Para. The case projected is that the Mandia Anchalit Panchayat in the district of Borpeta had published a notice inviting tender on 3/5/2023 for settlement of various markets, parghats, including market parghats, etc., including the Mili Juli market. Full stop. The term of the settlement was for a period of 1 year, ending on 30/6/2024. Full stop. It is the case of the petitioner that he, being the previous lessee, had participated in the same process by submitting all necessary documents. Full stop. The respondent number 5 was also one of the bidders. Full stop. It is, however, the case of the petitioner that while the bid submitted by the petitioner was valid in all respects, the bid of the respondent number 5 was defective, as most of the defective. Full stop. In this regard, Sri Sharma, the learned counsel for the petitioner, has referred to the comparative statement prepared for evaluation of the bids of the various bidders. Full stop. By drawing the attention of this court to the said comparative statement, Sri Sharma, the learned counsel, has submitted that while all the columns in the comparative statement pertaining to the bid of the petitioner has been held to be submitted, many of the columns for the bid of the respondent number 5 has stated that such requirements were not fulfilled by the respondent number 5. Be that as it may, on opening of the financial bids, it was found that the bid of the petitioner for an amount of rupees 9,21,102 was found to be the highest. Full stop. The respondent number 5, the financial bid of the respondent number 5 was, however, rupees 8,11,905, which is apparently substantially lower than that of the petitioner. Full stop. On 6/7/2023, a notice was issued to the petitioner by the authorities communicating the acceptance of his offer. Full stop. It is the case of the petitioner that such notice was received by him on 10/7/2023, and since he was suffering from illness, on 15/7/2023, he had gone to the office to deposit the KISS money. Full stop. On such approach, the petitioner was informed that on 14/7/2023, a notice was issued to the respondent number 5 regarding acceptance of the bid of the respondent number 5, and subsequently on 19/7/2023, the settlement order was issued to him. Full stop. Sri Sharma, the learned counsel, has submitted that in the affidavit filed by the department, it has been contended that the notice of acceptance dated 6/7/2023 was received by the wife of the petitioner, full stop. He submits that though the aforesaid statement may be a matter of fact, the assertion that the petitioner was unwell has been wholly ignored, and rather in the impugned resolution, it has been stated that no reasons have been cited for the delay in deposit, full stop. It is further submitted that so far as the documents are concerned, the guarantor of the petitioner had deposited all such documents on 7/7/2023, and therefore there was no default, full stop. It is otherwise submitted that along with the bid, all documents were deposited, were submitted, which is demonstrated by the comparative statement itself. Full stop. Para. Shri Sharma, the learned counsel, further submits that the impugned action of not allowing the petitioner to deposit the amount and making the settlement in favor of the respondent 5 is wholly unsustainable for more than one reasons, full stop. He firstly contends that admittedly, the bid of the respondent 5 was a defective bid, full stop. A defective bid, and therefore such offer could not have been given to the respondent 5, full stop. Secondly, he submits that from the information and documents gathered, the respondent 5 could submit the document after 10 days, which is beyond the period permitted by the terms of the tender, full stop. Thirdly, he contends that the price bid of the respondent 5 is substantially less, and therefore the impugned action is also against the public interest, full stop. He submits that there were cogent reasons for the delay, for the slight delay in depositing the case by the petitioner, which should have been condoned in the interest of justice, full stop. Attention of this court has also been drawn to the relevant clauses of the NIT, namely clause 10 and clause 20, full stop. Para. No, para. As per clause 10, a period of 3 days is given to the highest bidder for depositing certain documents which were yet to be deposited, full stop. As per clause 20, a period of a week is given for deposit of the kiss money, full stop. He accordingly contends that even going by a strict interpretation of the clauses, the petitioner would have made the deposit by 13/7/2023, and there was therefore a delay of only 1 day, which should have been condoned. full stop, para. Three. As Dr. Lalit's standing counsel of the department has, however, defended the action of the imputed action, full stop. He has submitted that the action is free from any malafide and has been taken strictly in accordance with law, full stop. He submits that the settlement was offered to the petitioner via notice of acceptance dated 6/7/2023, which was received by his wife. Full stop. It is further submitted that when the document could be submitted by the petitioner on 7/7/2023, there was no reason as to why the kiss money could not have been deposited. Full stop. By drawing the attention of clause 20 of the NIT, the doctor submits that the period prescribed for depositing kiss money is 7 days, is 1 week, which was admittedly over on 13/7/2023, and therefore on 14/7/2023, a resolution was adopted to offer the settlement to the respondent of 5, who was the second highest bidder. Full stop. The learned standing council accordingly contends that the writ petition be dismissed. Full stop. Para. Sri A.M. Khan, learned counsel for the respondent number 5, has endorsed the submission of the learned standing council. Full stop. He further submits that as per clause 10 of the NIT, 3 days time is granted for submission of documents, and therefore his bid cannot be held to be defective. Full stop. The learned counsel for the respondent number 5 categorically denies the contention of the petitioner that the land document was procured on 24/7/2023. Full stop. He submits that the document procured was not required to be manually signed, as it was digitally signed and was available and submitted within the prescribed time. Full stop. Para. The rival contention made by the learned counsel for the parties have been duly considered. Full stop. The original documents which have been placed before this court by Sri Datta have also been carefully perused. Full stop. Para. From the records made available, it appears that in the process of settlement of the aforesaid market in question, which was done through an NIT dated 3/5/2023, amongst others, bids were submitted by the petitioner and the respondent of 5. Full stop. There is no manner of doubt that the bid of the respondent of 5 was not complete in many respects, as many of the columns in the comparative statement had indicated that the relevant documents were not submitted. Full stop. Juxtaposed, the bid of the petitioner was found to be valid in all respects. Full stop. Apart from the aforesaid aspects, it is also required to be noted that while the bid of the petitioner was rupees financial bid, while the price bid of the petitioner was rupees 9,21,102 slash dash, that of the respondent 5 was rupees 8,11,905 slash dash. Therefore, there is a substantial difference in the price bid of the rival parties. Full stop. The version of the petitioner is that he had received notice of the acceptance dated 6/7/2023 only on 10/7/2023. Full stop. The said version, however, is not liable to be accepted inasmuch as the said notice was accepted by his wife on 6/7/2023 itself. Full stop. However, the mere fact of acceptance may not be the end of the matter. Full stop. It is the specific case of the petitioner that he was unwell and on recovery from his illness, he had submitted a representation on 15/7/2023 offering the kiss money. Full stop. A perusal of the said representation would show that he had also cited the reasons of the delay. Full stop. This court has also already noted above, that as per clause 20, a person, an incumbent gets a period of a week for deposit of the kiss money. Full stop. Though it may be a fact that such deposit was not offered within the prescribed period of 1 week, the facts and circumstances of a case would give a discretion to the authorities to take an action in a judicious manner. Full stop. The resolution, the copy of the resolution adopted on 14/7/2023 denotes that no reasons were assigned by the petitioner for the delay, which does not appear to be correct. Full stop. This court has also noticed that the bid of the respondent 5 was lacking in many respects and therefore could not have been held to be a valid bid. Full stop. Further, clause 10, which gives the leverage of 3 days for submission of certain documents, is only for the highest tenderer and not for anybody else. Full stop. Though there is a clause, though there is a part in clause 10 regarding the next highest tenderer, such next highest tenderer has to be a valid next highest tenderer, which cannot be held. Next highest tenderer, and in this case, the bid of the respondent 5 cannot be held to be a valid next highest tenderer, inasmuch as many documents were missing, were not submitted, as would be evident from the comparative statement. Full stop. The aforesaid fact of not submitting many documents is also not the subject matter of challenge in an independent proceedings till now. Full stop. In matters of distribution of state legitimacy, comma, no interference of this court is to be a restricted one, comma, the question of public interest, the issue of public interest cannot be wholly overlooked. Full stop. In fact, it is the issue which is of paramount importance. Full stop. The financial bid of the petitioner is substantially higher than that of the respondent number 5, and the settlement issued to the respondent number 5 is at respondent number 5, not at settlement level. Para. This court is of the opinion that the decision not to accept the price bid of the, not to accept the kiss money offered by the petitioner pursuant to the notice of acceptance dated 6/7/2023 is not, cannot be held to be justified. Full stop. Consequently, the settlement made in favor of the respondent number 5 dated 19/7/2023 is interfered with. Full stop. The writ petition accordingly stands allowed by directing the petitioner to offer the relevant kiss money for the remaining period within a period of a week, within a period of on or by today's 28, on or by 25th, on or by 25th of December. And on such offer, the same is to be accepted and the remaining period of the settlement be given in favor of the petitioner in accordance with law. The writ petition accordingly stands allowed. The records in original are handed over back to the Learned Standing Council. Okay. We'll give this back after some time.
My lord.
What is the name of the market?
Milizuli.
So we have
They
given.
can Milizuli.
Yes.
50-50.
That is the reason of this judgment. One part by you, one part by him, all milijuli.
All right.
High level.
Thirty. Mail hearing. Who's there? SSS Rahman. Kesdar is there.
No, sir.
We'll fix a date.
Interim is there, Lord.
No, we'll fix a date. It's not proper.
Okay.
Granting or not granting interim, that's a different matter, but you need to
Lord.
be given a date for production of the case diary. Case diary has not been received. None appears for the petitioner on call. However, pursuant to learned edition PP submits that case diary has not been received. First up, he further prays for fixing. Yes.
Lordship, I'm from the identity. I'm from the petitioner.
What is your name?
H. Farali.
You were with Mr. Rahman.
Lord.
Okay, non-request eligible. Three, so learned edition PP submits that case diary has not been received, and he accordingly prays for a fixed date for production of the same. Which Thana?
Lordship, Kapruk met.
Oh, list this case on 10th of January.
Yeah.
Para for production of case diary. Para interim order passed earlier to continue till the next date of listing. Mr. D,
May I please?
please, Jerry.
Please.
Yeah, okay.
My lord, petitioner before your lordship is
Yes.
a assistant teacher, my lord, government employee.
Assistant teacher.
My lord, Pramila Shankardev High School.
Okay.
My lord, is a father of 4 children, my lord. The informant before your lordship is a woman. She is the daughter of my lord Lolita Nikhil Rai, and she is the mother of 2 children, my lord. The allegation raised, my lord, in the FIR, my lord. Actually, these are all false and fabricated
Let us see. Let us see.
allegations, my lord.
Page.
Page 11, my lord. Page 11 is
You have
the
164.
particular, my lord.
Page 11.
11. The particular and translated copy, page 10.
Okay. Okay. Those house.
FIR was lodged on
Yes.
13/7/2021.
Mm. My God, the allegations are very serious.
My lord, the allegations are serious, but my lord, this is not correct, my lord.
No, that
These
is
are-
your version. Yes, 164.
Yes, one FIR, if I look into the FIR 164, 161, the material fact is same, there's implicated.
164 also. Let us see.
My lord, only see the FIR, it is raised that the accused number 1 entered into the room at 10 p.m., my lord.
Yes.
And by lumping the mouth of the victim, my lord, pressed out from the house and outside the house, and then committed rape. This is the allegation. And then after my lord committing rape, then he raised halla because they wanted to burn her. This is the allegation. But why not, my lord, raised halla before that?
Her mouth was shut.
Moreover,
My lord,
মই যোৱা 3 বছৰ ধৰি মোৰ বাইদেউ সুমিতা দাসৰ ঘৰত থাকো বাইদেউ
this is the, I have to explain, my lord, paragraph 5.
earlier rejected also.
নাথাকো
Yes, earlier at that stage, investigation was.
এটা হয় বাইদেউৰ ঘৰত ওচৰত নিশ্চয় যাব গোটেই ঘৰ আজি 3 বছৰ 10
More than 2 years back, my lord, FIR was lodged. Investigation perhaps complete. There's no chance of plea. He's a government employee, well, he will cooperate.
This is lodged when FIR? Which year?
2021.
21.
Why have you not arrested him?
Fleeing, sir. Look,
He is always doing the duties, school duties also.
Why have you not arrested him?
but he investigating officer were in search of him. But he is absent.
No, that's not. He's doing duty.
We'll have this on Monday. Come up with a report. Or not Monday, Friday. That you have arrested him. You are asking for AB in this.
My lord.
We
Earlier, my lord, it was rejected at that initially.
with this kind of allegation, you have not even taken him to custody. And you arrest persons with allegations of theft. 164 we are reading. We forget the FIR, forget the 161. Friday. Part 3 PC day. Learned counsel for the petitioner who has filed this application under section 438 of the CRPC in connection with so and so. Full stop. Pursuant to the order dated, pursuant to the orders passed earlier, comma, the case diary has been produced, which contains the 161 statement, which contains the statements of the alleged victim under section 161 as well as under 164 of the CRPC. Full stop. Perusal of the same, including the statement under section 164 of the CRPC. Prior leads one to conclude regarding the gravity of the offense, gravity of the allegations. Full stop. The FIR was lodged in July 2021, and it is failed to be understood as to why, with allegations of such allegations of grave nature, comma, no detention has been made. Full stop. The petitioner claims to be a government employee in the form of an assistant teacher in Pramila Sankardev High School, Simoluguri, in the district of Nagaon. Full stop. The investigating agency are required to submit a report regarding the steps taken to take the petitioner into custody for his examination. List on Friday. Para. Let a copy of this order be furnished to Sri So-and-so learned APP for onward transmission. Yes, next. Yes.
May I please note the first ground to which I would like to
Yes,
highlight
no,
is
no.
the delay in the trial. At the time of filing this petition, 816 days of my lord custody of the petitioner.
How many days?
816 days.
Let us read the.
It was filed on the my lord.
Let us see the FIR.
Yes. May I take what to the page 14, my
1/4, yes.
Yes. And the 16 is the OE method.
1.324 kgs of suspected heroin.
Yes. 6 of them were arrested and 2 have their bail petitions have already been allowed on the ground of this delay in the trial. And which I would like to place before this court the orders passed by this court in 2 bail petitions. Hello, this is bail application number 2110/2023.
Yes.
Yes, my lord. May I read out the para number 6, my lord? In the second page, my lord, I'm sorry. Second page, para 6. It is noticed that the accused petitioner has been in judicial custody since 29 August 2021, that is for 744 days,
Okay, we have read this.
my lord.
We have read this.
Yes.
Yes, what are your grounds?
Yes, second ground, and before that, before I come to the next ground, if Lordship permits me, may I just furnish Supreme Court judgment on the ground of delay where my lord, embargo on 37 will not apply. My lord will be
Statute will not apply.
will not apply.
Statute will not apply.
Will not apply because this is a contravention of my lord Article 21. Violation of Article 21. My lord, may I read out just for Para 4, my lord.
Para 4.
As regard
Yes.
to the twin conditions contained in Section 37 of the NDPS Act, learned counsel for the respondent state has been duly heard. Thus, the first condition stands complied with. So far as the second condition, read, formation of opinion as to whether there are reasonable grounds to believe that petitioner is not guilty. The same may not be formed at this stage when he has already spent more than 3.5 years in the custody. The prolonged incarceration generally militates against the most precious fundamental right guaranteed under Article 21 of the Constitution. And in such a situation, the conditional liberty must override the statutory embargo created under Section 37(1)(b) Roman number 2 of the NDPS Act. My lord will be satisfied on this matter. And then now coming to
What was the contraband here?
it's a heroin, my lord.
No, in this Supreme Court case?
Oh yes, my lord.
Ganja.
Yes, ganja. But the punishment is the same.
247 kg of ganja.
Yes. Punishment is Section 20(b) Roman number 2 clause C. It's the same punishment. Minimum 10 years with pay go up to 20.
NDPS Act concern.
B Roman number 2 capital letter C clause C, and involve commercial quantity with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to 20 years. Punishment is the same. So,
Okay.
Yeah, if Lordship is pleased with the first ground, I may not go into the second ground, but if Lordship.
First ground mean?
That is my first ground.
Which one?
For bail, that delay in the trial. Yes.
No, that is not, you make all your grounds.
Yes. Second ground is, my lord, may I take Lordship to the my petition?
Yes.
Page 8 of my petition.
Yes.
I may be allowed to read out just the portion. Prima facie not guilty for the purpose of section 37. My lord, I'm very specifically using for the purpose of 37, my lord. Here, I said that the applicant humbly submits that looking at the available materials on record before the trial court, there is no prima facie chance of proving the guilt of the accused, which is the ground for bail, and to cross the embargo imposed by 37 of the NDPS Act on the following facts and grounds. The first point is non-compliance of section 52A of NDPS Act. That the materials
Those will be materials on merits. We are not going into the merits.
My lord.
Why prima facie you are not saying? Let us see the FIR again.
My lord, before that, Lordship, if Lordship permits me, may I be just allowed to read out just two paragraphs of the Honorable Supreme Court judgment on the interpretation of this, my lord, not guilty for the purpose of section 37. For the purpose of section 37, what is the scope of the, my lord?
No, what are the wordings in 37?
Yes, my lord.
What is the expression used?
Okay. 37. Yes, my
That,
lord.
that believing that he is not guilty of such offense.
For the purpose of 37. For the
Yes.
purpose of 37.
Yes.
Yes. My lord, 37 1B, my lord, Roman number 2.
Yes.
Yes. This is the embargo, where the public prosecutor opposed the application.
Now, this the decisions you are citing for what purpose? Which one?
Yes, my lord. May I take Lordship to the Muhammad Muslim, my lord?
Yes.
Yes. Now, may I take Lordship to para 18 is at page 11, my lord.
Yes.
The conditions which courts have to be cognizant of are that there are reasonable grounds for believing that accused is, quote and unquote, within the court, not guilty of such offense, not guilty of such offense, and he is not likely to commit any offense while on bail. What is meant by not guilty when all the evidence is not before the court? It can only be a prima facie determination, my lord.
Yes.
And that places the court's discretion within a narrow margin. Now, may I take Lordship to page 13? Very conclusive interpretation.
Yes.
I would be reading only para 19 and 20. A plain and literal interpretation of the condition under section 37 that court should be satisfied that the accused is not guilty and would not commit any offense, close bracket, would effectively exclude grant of bail altogether, resulting in punitive detention and unsanctioned preventive detention as well. Therefore, the only manner in which such special conditions as enacted under 37 can be considered within, my lord, this is very important, within constitutional parameters is where the court is reasonably satisfied on a prima facie look at the material on record. My lord, I emphasize this. I would come to this material record. Whenever the bail application is made, that accused is not guilty. My lord, any other interpretation would result in complete denial of the bail to a person accused of offenses as those enacted under section 37 of the NDPS Act. My lord, may I be allowed to continue para 20? Yes. Very crucial. The standard, this is very important, the standard of determination, my lord.
To be considered, therefore, is one where the court would look at the material in a broad manner and reasonably see whether the accused guilt may be proved, my lord. I may end here, my lord. Now, I would like to take lordship to the material now. Now, to look at the broad view of the material, it has to be the charge sheet map. Now, charge sheet is at page 21 of the petition map. And I would just go to the page 22 because the materials are mentioned. Page 22.
Yes.
After the last paragraph, along with the charge sheet attached, my lord.
Yes.
Number one is sketch of the place where incident took place. Number two is seizure list. Number three, FSL report. Only these three. Only these three. Now, my ground why he cannot be convicted is there is no compliance of section 52A, which the Supreme Court says that not only the Supreme Court, the statute itself says this is a my lord, primary evidence. Now, for that, first, before coming to the apex court decision, my lord, I would like to take lordship to the section 52A.
Yes.
My lord, section 52A. Subsection 2, my lord.
Yes.
Yes, my lord. For brevity, I may be allowed to jump, my lord, that where any narcotic drug, psychotropic substances, controlled substances, or conveyances has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered
You are
under
reading what?
my lord,
Subsection
subsection 2 of section 52A.
Yes, any person.
Yes. So, where any narcotic substance, psychotropic substance, controlled substance has been seized and forwarded to the office.
Which one? 52A of the?
Subsection 2, I'm so sorry. Of the NDPS Act.
Okay. Yes, please.
May I read it out
Yes,
again?
yes.
Where any narcotic drug, psychotropic substances, controlled substances, or conveyances has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53. The officer referred to in subsection 1 shall prepare an inventory of such narcotic drugs, psychotropic substance, and may I be allowed to jump to the last sentence, and my lord, at the end, and makes an application to any magistrate for the purpose of certifying the correctness of the inventory so prepared. Number B, taking in the presence of such magistrate photographs of such drug substance or conveyances and certifying such photographs as true. C, allowing to draw representative samples of such drugs or substances in the presence of such magistrate and certifying the correctness of any release of the samples so drawn. Now, may I go to my lord subsection 4? Notwithstanding anything contained in the Indian Evidence Act 1872 or the CRPC 1973, every court trying an offense under this act shall treat the inventory, the photograph of narcotic drugs, psychotropic substances, controlled substances, or conveyances, and any list of samples drawn under subsection 2 and certified by the magistrate, my lord, is primary evidence in respect of such offense. If these are absent, there's no primary evidence. And therefore, the Supreme Court says it vitiates the trial. And this is what I would like to bring home, that here, my lord, may I first come to the Supreme Court ruling on this point, my lord. If Lord, okay. This is Yusuf, my lord. Yes, Yusuf. My lord, may I take lordship to page 8? Pagination is at the bottom, my lord. Page 8, para 13. No,
Yes.
Yes. Notwithstanding the defense set up from the side of the respondent in the instant case, no evidence has been brought on record to the effect that the procedure prescribed under subsection 2, 3, and 4 of the section 52 of NDPS Act was followed while making the seizure and drawing samples such as preparing the inventory and getting it certified by the magistrate. No evidence has also been brought on record that the samples were drawn in the presence of the magistrate and list of the samples so drawn were certified by the magistrate. The mere fact that the samples were drawn in the presence of gazetted officer is not sufficient compliance of the mandate of subsection 2 of section 52A of the NDPS Act. My lord, may I lastly take to the next page 10, para 16 and 17, my lord. That will end, my lord, the reading of this Supreme Court judgment.
Yes.
Yes, my lord. In the absence of any material on record, this is very important in my case. Page, no, para 16, my lord.
16.
Yes, 16. This is page 10.
Yes.
Yes. In the absence of any material on record to establish that the samples of the seized contraband were drawn in the presence of the magistrate and that the inventory of the seized contraband was duly certified by the magistrate, it is apparent that the said seized contraband and samples drawn therefrom would not be valid piece of primary evidence in the trial. Once there is no primary evidence available, the trial as a whole stands vitiated. Para 17, my lord. Accordingly, we are of the opinion that the failure of the concerned authorities to lead primary evidence vitiates the conviction, and as such, in our opinion, the conviction of the appellant deserves to be set aside. The impugned judgment and order of the High Court, as well as the trial court, convicting the appellant, sentencing him to rigorous imprisonment of 10 years with fine of 1 lakh and in default payment of fine, my lord. My lord. So therefore, when there is no material, my lord, to show that there is a compliance of section 52A, then the trial itself is vitiated. In that event, my lord, when that primary evidence is not there in the charge sheet, my lord, then the trial has to fail. Now, the only thing which this honorable court has to consider in the backdrop of the law, which says that guilty, reasonable ground for this honorable court to come to a conclusion that he is not guilty would mean, my lord, by looking at the broad view of the materials, whether he can be convicted or not. Here, he can never be convicted. And therefore, it is a good ground for bail. Why? Because my lord, continuation of the incarceration, my lord, violates Article 21. Yes, it was already held in the several, my lord, Katina of judgment. If I want to.
No, we'll hear you. Anything else?
My lord, I have. And my lord, in ground C, that is page 10 of my petition,
okay.
Which is also equally important.
Page 10?
Yes, ma'am. Page 10 of my petition, ma'am. C. Reasonable grounds for believing that accused is not likely to commit offense while on bail. That in view of the fact that accused is an innocent farmer and also having no criminal antecedent, my lord, this is the point, no criminal antecedent, is not likely to commit offense in the event of being released on bail. Just my lord, a clear view of the manner in which my clients were arrested. They were traveling in a bolero, 4 of them. And my lord, till today, after my lord arrest, the prosecution has not identified who is the owner of the vehicle, who is the owner of the narcotic truck, and what is the specific involvement of these 2 clients, my lord, so far. And therefore, it is, my lord, it is no material what is to be proved against me of the petitioner. So therefore, it is a vague kind of allegation as of now. The only, my lord, available statutory statement is against those who were already allowed bail where they said the destination is to those two accused who were released on bail. That is the only material. Besides that, no material, my lord. Now, coming to non-compliance of clause 1.13 of standing order 1 of 1988 is page 9 of my petition, my lord. This is the last ground. Okay. My lord, I'm taking a lot of time, but may I be allowed to just submit Delhi High Court judgment, not because of the judgment, but I'm so sorry. We are unable to get a copy of this standing order, and we are trying to rely on this, my lord, the reproduction of the standing order. Huh? My lord, if lordship is page 11 of the judgment, the pagination is at the bottom.
Yes.
And this, my lord, the standing order 1 of 1988 reproduced here, and I would like to read 1.13, mode and time limit for dispatch of same to laboratory. May I start? Sir?
Yes.
Yes. The samples should be sent either by insured post or through special messenger duly authorized for the purpose. Dispatch of samples by registered post or ordinary mail should not be resorted to. Samples must be dispatched to the laboratory within 72 hours of seizure to avoid any legal objection. This is the only portion which I would like to read, my lord, besides page 17, my lord. Just one short paragraph that will end my text.
Yes.
Yes. The first para, that is para 16, my lord.
Yes.
Guidelines prescribed in the standing orders cannot be flouted, and their substantial compliance must be insisted upon, as observed in Nur Aga Supra. This court has already held standing order 1 of 88 to be mandatory in the judgment in the Lakshman Thakur versus State in bail petition number so and so. My lord, here also the bail was allowed for the non-compliant, my lord. I just wanted to, I have read it only for the purpose of placing the standing order. And with this, I wind up my lord, submission for the bail.
Yes, yes. Yes, what do you say?
First, I want to state here, Lord. The charges are paid from 9/3/22, Lord. And moreover, 3 witnesses has already been examined. One of the witnesses is
How many PWs?
9, Lord.
Three PWs examined.
Examined, Lord.
Okay.
And moreover, my lord, on last, it is reflected on the order, Lord, on 14/12/2023, Lord, fixed for evidence.
Okay.
So trial is going on regular basis, Lord. So delay is not there, Lord. First, Lord. It is going on regular basis, Lord. Moreover, my lord, here my learned friend has cited one Ravi Prakash versus State of Odisha. If you look into the para 3, Lord, where the contraband is ganja, Lord.
Yes.
Here it is clearly stated that we informed that the trial has commenced, but only 1 out of 19, Lord. At the trial stage, my lord, only 1 out of 19. Here, this is not the case, Lord. So delay is not there. Moreover, on the part of the guilty,
a prima facie, my lord. Moreover, my learned friend has also talking about under technicality. But this is a bail application, my lord. So we are not going on that, my lord, on the merit of the case, lordship. We are on the prima facie case, lord. So if we look into the seizure, lord,
Yes. Page
page 28, lord.
Yes.
One, there is a description of seizure article, my lord. One notice there, my lord. Lordship, what?
Yes.
The above articles are kept concealed under the dashboard and inside both the backlights of the above noted vehicle, lordship. And both these persons in the FIR, if you look into the FIR, lordship, they were present because they are named in the FIR, lordship. These persons are there. Moreover, if you look into the seizure witnesses, two of the seizure witnesses are already examined, lord, and others are still there. And moreover, informant has not been examined, lord, till now. Vital evidence, lordship, depositions of informant, lordship. So his deposition is not yet examined, lord. Here, the seizure witnesses also stated that there are 4 to 5 persons that are in the vehicle. So in the conscious position, these persons are in the conscious position. But moreover, if we look into the FSL report, lordship, the heroin percentage of heroin is 78.85, lordship.
Where?
Lordship, the FSL report. Lordship, in page 70.
Page?
17, 17, Lord. Oh, sorry, Lordship, with 34. I apologize.
Yes.
Got it. Lordship, with the result of the examination, the exhibit to Lordship gave positive test for heroin, and the percentage of heroin in its exhibit was found to be 78.85. So, Lordship, there in the part of the delay, there is no delay, Lordship. It is continuously going on, Lordship. Secondly, in the part of the guilty, my lord, prima facie it has been established. They are in the conscious position. They are in the vehicle, lordship. It is established. Also, informant has not been examined, though not examined. But the seizure witnesses have stated that they are a person. FIR name, lord. They are named in the FIR. So prima facie it is established, my lord. And moreover, in technicality part, we are on the bail, lord.
He is made a substantial argument on with regard to the charge sheet,
Lordship,
which also mentions about 3 enclosures.
Lordship.
By bringing in 52A.
Lordship.
Section 52A. If you come to the charge sheet. Where is it?
Okay, fine.
Where do you stay? Where do you stay?
My lord,
Where do you stay? Where is your residence?
my lord, he is a resident of Chochanpur district.
Now, presently, at the time of the offense?
Offense, they were coming from Manipur towards Guwahati.
No, no, otherwise, where are you staying?
They were just coming for the medical check.
Medical checkup?
Yes. That is not mentioned in the petition.
You said you're a farmer.
My
Why are you coming to Guwahati?
I thought that.
No, no, just asking. You had
Yes, yes,
said
ma'am.
many things.
Yes, ma'am.
You must have stated somewhere why were you coming, or
Oh, yes, that I'm very sorry, ma'am.
you have not stated anything.
Yes.
Where have you stated you are a farmer?
Oh, yes, my lord. At page, my lord. Yeah, page 10, ma'am.
Page 10?
Yes. C, which I have read. That in view of the fact that accused is an innocent person, also having no
That
criminal.
we have seen already. What farming do you do? What kind of farming?
My lord, cultivator, there it's my lord, petty farming.
Paddy. What is your age?
36. My lord, may I be allowed to point out just two things which I missed to?
You have already made your submissions.
Yes.
We're looking into the records now.
Right.
Number. How many witnesses examined?
3, Lord.
3. This samplings, everything was done in presence of a magistrate. You are putting emphasis on 52A.
Okay, my lord. That I have read it. Certifying the correctness of inventory, number 1. Certifying the correctness of the photograph, number 2. Number 3 is
What
certifying.
is the expression used?
My lord.
What is the expression used?
Oh, yes, my lord. Section 52A, subsection 2, and then A, B, C.
4.
Yes.
Notwithstanding anything contained in the Indian Evidence Act and the CRPC, every court trying an offence under this section shall treat the photographs so and so, so and so, so and so as primary evidence.
Certifying them to be true.
Yes.
There's no photograph also. There's no
those
even
will be
photograph.
treated as primary evidence.
Yes.
Now this is only an enabling section.
Yes.
It gives the power to the prosecution in the trial that these things which are certified by the magistrate will be treated as primary evidence.
Yes.
But this is not exclusive. There can be many other primary evidence.
My lord, lordship is right, but at the same time, for the purpose of bail, Supreme Court has made it.
No,
very
this,
clear.
how does it help? You are trying to understand. 4 says that few things which are certified by a magistrate would be treated as primary evidence.
Yes.
Now, assuming that there are no such things in this case.
Yes.
Can this be the only primary evidence in a case of NDPS?
Oh, that is what the Supreme Court says. When that, in absence of that, the trial is vitiated.
In absence of primary evidence, trial will be vitiated.
It says.
But are these the only primary evidence?
And that is what the Supreme Court
Let
has.
us see.
Because of the mandatory nature of the provision, my lord.
Let us see page.
The Yusuf, my lord.
Yusuf,
Yusuf versus state. Page 10.
Yes.
Page 10, para 16.
Yes.
16, para 16 and 17.
See, in absence of any material on record,
yes,
to establish that the samples contraband were drawn in presence of a magistrate and the inventory of the seized contraband was duly certified by a magistrate, it is apparent that seized contraband and the samples drawn would not be a valid piece of primary evidence in a trial. And once there is no primary evidence available, the trial.
Yes, that's what.
This talks about primary evidence.
Yes.
It doesn't say that these are the only primary evidence.
Yes,
And there are materials in the scan copy where presence of the magistrate has been recorded. Magistrate has himself said.
My lord, I agree with lordship when it comes
Where
to
the officer applied to me under section 2 of section 52A to certify the above inventory. There is a note, certification is there.
My lord, there's no certificate.
It is in the record.
My lord, one thing is, my lord, here, in any other,
in any case,
any other trial, my lord, I agree with lordship.
In any case, this matter is against an order of conviction.
My lord.
This was not a consideration for a bail.
But
Yusuf was against an order of conviction.
Once there cannot be a conviction, then obviously the law laid down by the Supreme Court.
Without even the evidence, will hold that you are not guilty.
Or
you are guilty.
Of looking at the broad view of the record, my lord.
See, we are just considering our bail application.
My lord, two things I would, my lord. Only two submissions, my lord. Only
see, there are. Let us be very clear. You are going slightly deeper.
Yes.
In a bail application, we are only on a prima facie view. We don't want to make any observation which may cause prejudice to either of the parties.
Yes,
not to you, not to him. If I say something now, there will be prejudice. If I say something now in his favor, he will be prejudice.
I agree.
Higher court has said this. How can a trial court now say something else?
That's true.
You are making a submission based on a prima facie view, whether these materials are enough. Yes, delay is an independent ground, you can say.
Yes.
816 days.
Yes.
But if you go on 52A, subsection 4, then the case clause, then okay, we'll see.
My lord, just two sentences, and I'll, if lordship permits me.
Yes.
Just two sentences. The first sentence is that, my lord, I agree with lordship that primary evidence can be brought in from any other angle, any other source during the trial. I agree. In other cases, but in NDPS, my lord, at least because of the mandatory nature of the provision, my lord, that is made mandatory. Otherwise, I agree with lordship is right.
No. If you let us again,
yes.
For read 4, what does it say? It says that inventory which is certified by a magistrate shall be primary evidence.
Yes.
That is what it said. It does not restrict any other primary evidence.
Yes, and read with Supreme Court judgment that when there is no primary evidence under Section 52A, then the trial is yet.
But
My lord.
the record says something else. There is certification.
My lord, so far as the certified copies we have obtained, my lord, as I have already shown this
You
on to,
you can have a look. There's no difficulty in letting you have a look.
because in the charge sheet,
Eh.
in the charge sheet, only three things are enclosed, my lord. One is
See,
care.
there may be many things omitted, there may be things written. We have to look at the entire materials on record. Just have a just one glance, one glance. দিব নালাগে চাব দিলে হ'ল just one glance. লৈ আনা চাব দিলে হ'ল দিব নালাগে চালে হ'ল খালি So,
My lord, the inventory, yes, it is certified. Inventory. But my lord, the other factors, that needs to be certified are not certified.
And you have not stated anything in your application.
My lord.
How are you found? Why are you say that you are just traveling a farmer or why are you in the Bolero? You are not denying your presence.
My lord.
Are you denying your presence in the Bolero?
My lord, I don't deny my presence.
Then why were you there?
My lord, we were coming for a medical check.
Medical, you have not stated anything. What was the ailment? That is why we had asked about your age. You are 36.
Yes, Lordship is right.
36 years.
Yes, Lordship.
Some ailment must be of serious nature that you come all the way from Manipur to Guwahati. What was the ailment?
My lord, it was only for the purpose of the health check. Everyone comes for health checkup here in Guwahati. Not
along with medicines.
No. My lord.
Consult medicines.
My lord, prosecution has not said single word who owns the vehicle, who was the driver. The vehicle was, my lord, in such a way modified to the extent that, my lord, the drugs were concealed in the dashboard and the
backlights.
Headlight.
Backlights.
So therefore, anyone traveling with any friend can always land up into my lord, this situation. That is.
But you are for two.
My lord.
You are not for one.
My lord, 4 of us.
Out of 4, 2 are innocent.
Four.
And 2 remains. They said they are also innocent.
They are still, my lord, there.
What would be the value of this 1 point something kilo of heroin?
I have no idea, my lord.
Roundabout.
Right.
Around 2 crores. Nobody is taking claiming ownership.
My lord, I have
of 2 crores property.
My lord, I'm taking time, but just two sentences about my.
Okay, we'll consider.
Yes.
We'll pass orders.
Yes, sir. Right.
And the other one?
Same petition. Every method paragraph that.
No. Who is the petitioner?
He is the accused himself.
No. Who petitioner is who? Some other person. What does he do?
My lord, he is also, my lord, a farmer coming with his friend. His petitioner.
He is also a farmer.
Yes.
All farmers traveling together.
2 of them, my lord.
Same innocent farmer.
Yes.
Not a farmer. He's an
Yes.
innocent farmer.
Yes.
Full test of. What is flight risk?
My lord.
What is flight risk?
Oh, yes, I'm sorry. My lord, they'll be here in God, my lord. Right now, they cannot go back to transport.
No, what is flight risk? You have
Flight
said,
risk, my lord, they will not run okay.
no, they has no power and strength to
Oh, yes,
fail.
yes,
The
yes.
triple test of flight risk. Flight
Yes.
risk means
They won't abscond, they won't dumbbell.
flight risk, tampering with evidence, we understand.
Yes.
Intrinsic witness, we understood. But what is flight risk?
We mean to say that they would run away from the trial.
We're retaining this scan copy. We'll pass out this.
Give the outside.
ST comb, your ST comb.
Yeah, T comb. Some clients might not would hunt for the name, whether we deal with certain cases for which my lord, the full name is preferred. T comb.
Okay. Mr. Chaudhary. Did we commit?
My lord, my learned friend is in a hurry. They have got
No,
a-
did we commit anything?
Not really.
No, I was wondering, I was remembering a movie. Once commitment is given.
Yeah.
In fact, we are discussing about the movie with somebody today. If we have committed, we'll have to hear. We are at your mercy.
So, my lord, we are at your worship. I think my
Yes, if you want, we can. Yes, it's on. What is body or it is on? Yes. How long will it take?
on the time I want to make a submission. There is an interim order.
What was it? Just 2 minutes, if you can just refresh. এইটু লাগিব What was it actually?
My lord, 3 tender notices pertaining to supply of micronutrients, fertilizers, and pesticides. My lord, these 3 identical notices, e-procurement notices were issued. And the petitioners are the manufacturers. And my lord, there was a corrigendum which disqualified the petitioner. The corrigendum states, my lord, the manufacturer has to have an experience of supplying 30% to the extent of 30% of the supplies to government department or PSU. So, my lord, that disqualifies us. So, we have challenged that corrigendum. Now, what happened, my lord? There is an interim.
You have to have supply experience of 30%.
Yes, my lord, 30% to government department or PSU. Government department undertakes or PSU.
Okay.
That was the requirement that was incorporated by way of
Corrigendum.
We have challenged that corrigendum on the ground that the requirement in your original NIT, and also my lord, they are relying on the standard bidding document that does not require that supply, my lord, supply to the government department. We are manufacturers. We have got many, my lord, distributors all over the country. In fact, my lord, the first petitioner has about 5,000, my lord, distributors in state of Punjab itself. Now, we do not supply to government departments for obvious reasons, my lord. The payments part is always, my lord, is a problem. But then, my lord, our dealers, they supply. Now, that requirement of supplying to the government department is, my lord, that is under challenge, which is not in the, my lord, standard bidding document also. Now, what happened, my lord, this honorable court had given an interim order, and my lord, by virtue of that, we have been able to participate. And my lord, to my information, to instruction of my client, the technical evaluation has been made. Now, my lord, they are in fact free to open the price bid also. In the event, my lord, in the price bid, we do not become the
Then
lowest
case is
bidder.
gone.
That is the end of the matter.
Okay.
So perhaps, my lord, instead of hearing the entire matter, perhaps your lordship may leave it to them to open it. And if we are the lowest bidder, then you will examine, your lordship will examine the matter. I think that
Have
will
you
be.
gone ahead with the financial bids? No.
No,
You open it.
my instruction is that the technical evaluation has completed within a day or two. It is going to be placed before the bid committee.
Okay.
After that, only the finance part.
Okay, you go ahead with the opening of financial bids. Don't allot it.
Don't allot it
And
place it
before this court. If he's out on financial, there is no need for adjudication.
Yes.
He only wants a fair consideration, and fair consideration is only at the mainly at the technical part, because he was aggrieved by that part of the corrigendum incorporating some new new requirements, which he says may not be relevant.
That is not, my lord, that is not.
That part we are still open. We have not decided anything. But since they in pursuant to the interim order, his bids have been accepted by you, and technical evaluation has been done, deholds that requirement. You open the financial bids. Then at least you can go one step ahead.
Yes.
And place it before the court, my lord. If we are, my lord, the lowest one, then your lordship will consider our case. Otherwise, my lord, maybe your lordship may not.
Okay, okay. It will not require much time, even on the next day. You just need to place before us what is the reason of inserting the corrigendum.
That reason, my lord, they have given in the affidavit, they have given that, my lord, we have countered that also. To satisfy your lordship, my lord, that.
What is the primary reason?
Primary reason is that, my lord, they say that the requirement of supply to the government department is there for the, my lord, the three categories can apply, my lord.
Okay.
One is the manufacturer, the other is the, my lord, dealer, distributor, and third is the, my lord, authorized importer.
Okay.
So for dealers and distributors, that supply requirement is there. In the standard bidding document that they are relying also, my lord, there that requirement is there. But for the manufacturer, my lord, that requirement is not there in the standard bidding document. They say that in order to get in the level playing field, they have done it. But my lord, here is a case where they are ousting the, my lord, manufacturer. On the dealers will supply from us only, the manufacturers only, and they are, my lord, disqualifying the manufacturers from purchase. That is our case.
You want a smooth supply, actually. That is your main purpose.
Yes.
That if a person without experience is given the, he may not be able to supply. But they will probably have some other answer that. Okay.
Because my lord, there is
three petitions are there. Three petitions.
Three petitions on the same ground, my lord. Only, my lord, the items are different.
A common order, heard Sri M.K. Chaudhary, Learned Senior Counsel for the petitioners.
Lordship, one aspect will be there, if the financial bid is open and it's in the e-portal, then the time frame will come to give if that's the software.
We'll say something. And we'll fix a date early on the reopening, not.
Yes, on the reopening.
We can have it on 3rd itself or 4th.
Yes.
4th. Okay. Heard Sri so also heard Sri B. Chaudhary, Learned Standing Counsel, Agriculture Department. Full stop. The subject matters of dispute in these three cases is with regard to a e-procurement process for supply of various agricultural commodities. Fertilizers.
Fertilizers, one is micronutrients, another is biofertilizer, and the other is pesticides and weedicides.
Agricultural products, namely micronutrients,
Biofertilizer,
biofertilizers, and third is
pesticides and
pesticides
weedicides.
and weedicides. Listen. The grievance of the petitioners is connected with a corrigendum
Dated
published by which manufacturers, by which an additional condition is attached if the bidder is a manufacturer, full stop. The said condition is the requirement of having 30% of requirement of having experience of supplying 30% of similar items to government departments, PSUs, full stop. It is the case of the petitioners that such requirement are not relevant, and only because of the fact that the petitioners may not have the requisite experience, they should not be debarred from participation
When they fulfill all other requirements.
In the process, full stop. It is submitted that apart from the aforesaid requirement, the petitioners fulfill all other requirements, full stop. This court has been informed that an interim order was passed and is operating in this field, as per which the petitioners were allowed to participate in the technical evaluation, pursuant to which they had offered their bids, full stop. Sri Chaudhary, the London Standing Council, B. Chaudhary, London Standing Council, further submits that the technical evaluation has been done and the stage is for financial evaluation, and because of the interim order, public interest is being adversely affected, full stop. The Senior Counsel for the petitioners at this stage has put forward a suggestion that the financial bids may also be allowed to be opened, which, however, opened, full stop. However, no final orders be passed regarding allotment without taking leave of this court, full stop. This court is of the view that the aforesaid suggestion is a reasonable one, as in case the petitioners are not able to compete in the financial bids, there may not be any further requirement of this court to examine the issue, full stop. The London Standing Council of the department, though fairly accepts the aforesaid proposition, has, however, submitted that since the opening of financial bids is on e-mode, after a specified time, the allotment order would be automatically issued, full stop. Considering the aforesaid facts and circumstances, the department is permitted to go ahead with the process of opening the financial bids of the respective of various bidders, including those of the petitioners, and place the result of the same before this court on the next date fixed, which is 4/1/2023, full stop. As regards the technical issue of a technical issue involving the consequence of opening by e-mode, it is made clear that final orders of allotment would be issued only after leave is granted by this court.
Earlier.
Sri B. Chaudhary, Learned Standing Council, will produce the results of the financial evaluation in a seal cover before this court on the next date fixed. Okay. Rest, we have to give dates. Mr. Biswas, Mr. Sharma, we're waiting for long.
That would take time. Also responded, but for 2 weeks.
Item number
37.
37.
Yes.
Heard Sri S.C. Biswas, Learned Counsel for the petitioner. Para. Sri A.K. Sharma, Learned Counsel for the respondent, sole respondent, prays for and is granted 3 weeks' time to file a in opposition. Mr. Gogol?
Amendment petition.
Amendment.
Prayer proposal.
Amendment?
Yes.
What amendment?
We have challenged the need and all, but we have not invalid, not challenged the correndum.
Who's for the other side?
It does.
Oil India. Oil India will have to hear. Have it on the reopening. Okay, we'll give a date. Back it on.